versus Lewis, appellant.
Good afternoon, Your Honors. Appellant requests 4 and 1.
Respondent requests 5 minutes, please.
4, 1, and 4. Solid State Elevator versus New York City Department of Buildings, appellant. Respondent? Submitted. Wanda versus Mark is submitted. Downing Street versus Solomon, appellant.
Appellant 5-3. Respondent
5, 2, and 5. Dubrino versus Rockefeller Center, appellant.
Appellant 5-2.
Respondent 5, please.
5, 2, 5, and 5. People versus Bartley.
Appellant 4 and 1.
Respondent
4, 1, and 4. Hartree Partners versus Vaquero, appellant. Wait, I'm seeing 3 people. Is there only 2 parties on this?
There are 2 parties, Your Honor. I will be
Okay, and how much time are you requesting?
Respondent 5.
6, 1, and 5. Castaldo versus FG Schiame, appellant.
Appellants 8 and 2, please.
Respondent. 6, 1, and 5. Arc 55 Doe versus Archdiocese, appellant. Respondent.
Respondent 7.
5, 2, and 6. People versus Castro, appellant.
Respondent 2, Your Honor.
3, 1, and 2. 35 West Realty versus Bastoon, appellant.
Appellant 8 and 2, please.
Respondent.
Respondent 7, Your Honor.
6, 1, and 6. Redrill Witt versus Algoma Hardwoods, appellant.
Appellant 8-4, please.
Is
Respondent 3, please.
4 and 3. People versus McKinney, appellant. 4, 1, and 4. Lee versus Karam. Is the appellant here on that? Okay, that is submitted. Bloom versus Hilbert. Usually when there's only one side, we submit, but I'll give you 3 minutes. Chavez versus Cirilla, appellant. 4, 1, and 3. 214 Lafayette House versus Acasa Holdings, appellant. 6, 1, and 5. People versus Rivera, appellant.
Respondent requests 2, Your Honor.
3, 1, and 2. And Max versus ALP is submitted. People versus Lewis.
Good afternoon, Your Honors, and may it please the Court, Rebecca Martin for Appellant Saul Lewis. Your Honors, this is fundamentally about what needs to happen before forfeiture of personal property can be made part of a plea bargain. We argue that this forfeiture was invalid for 2 independent reasons. First, that the way it was imposed violates due process, and second, that there's no statutory basis for
Well,
the
why don't we start with a preliminary question of
Yes.
whether it's even part of the criminal conviction or not? Because obviously, if it's not part of the criminal conviction, we don't need to get into
Yes,
it.
Your Honor.
And there's a real question about that.
Yes. So this agreement to settle the civil forfeiture was made part of the entry of the plea of guilty under CPL 22056.
Was it included in the conditions of probation?
No, Your Honor, but it was part of the plea
Was
and
it so
sentencing.
ordered by the court?
It was included as part of the plea and sentencing, like on the plea and sentencing sheet The court brought it up as part of the plea agreement, and it was
mentioned at the sentence, as part of the sentence?
it was not mentioned at the sentence, but it was.
Aren't all those factors which would indicate it's a civil forfeiture rather than part of the criminal conviction?
But, Your Honor, it was part of the plea agreement, and thus part of the entry of the plea of guilty, which is part of the conviction under CPL 1.2015. And as this court said in Burgos, anything that is part of the conviction, of the judgment of conviction, can be reviewed by this court.
But the court didn't ever so order it, correct?
No, Your Honor. So we would simply argue that as it was part of the plea agreement, that it must be reviewable by this court.
And where exactly in the agreement itself did it state that it was part of the plea agreement?
The forfeiture agreement, it doesn't, which is one of the flaws of the forfeiture agreement. But again, it is written down on the plea and sentencing sheet, and the judge did discuss it as part of the plea agreement during the plea.
Where in the record did the court discuss the forfeiture agreement as part of the plea?
I believe that, I do not have that in front of me, but I believe it was page 2 of the minutes. He says there's a waiver of money here. And then again, after there's a little off-the-record discussion, he says there's a waiver of money, which is very clear that when he says waiver of money, he's referring to this forfeiture. And again, it is also written, waiver of money is written on the plea and sentencing sheet under the plea agreement. So that is our argument for why it is reviewable. As to the substance, I want to focus on the due process point, which is simply that if you look at this forfeiture agreement, what it is asking Mr. Lewis to give up is not only his personal property rights, but all of the due process rights that normally attach before the government can take someone's personal property. The whole point of these civil forfeiture proceedings is that those are what provides the due process. If there had been a hearing, he would have been able to, submit more evidence about the fact that this money came from Social Security, is not part of drugs proceeds, and there's a reason that both the New York State and the federal Constitution have those protections in place. He's being asked to waive due process protections, which obviously he's allowed to do as part of a plea agreement under 22056, but all we're arguing is that just like any other time that someone waives a substantial right, as during a plea proceeding, such as the right to appeal or the right to prosecution by information, the trial court has to do something to make sure that they know what they're doing when they waive that substantial right and that that's on the record.
Counsel, he can challenge it civilly, correct?
I believe there may have been a mechanism to do that.
And
but
then he would get due process in that procedure, correct?
Well, given that he's already signed this forfeiture agreement, there might have been challenges, the same challenges that are raised here, which is that you already signed this agreement. And the fundamental problem is that the criminal judge is the one who's overseeing the signing of that agreement. No one ever made sure, no judge ever made sure that Mr. Lewis knew what he was doing when he waived his rights.
May it please the court, Oliver Lee for the people. Good afternoon, everyone. Your Honors, defendant's forfeiture stipulation is separate from his judgment of conviction and therefore not challengeable on his direct appeal. The plea and sentencing court didn't order forfeiture or indirectly pressure the defendant to agree. The facts of this case are most analogous to People v. Abruzzi, and therefore this court should dismiss as not properly before this court. Additionally,
What about opposing counsel's argument that it was part of the plea?
Your Honor, it was part of the plea agreement. However,
What impact should that have that it was part of the plea?
I'm sorry, Your Honor?
What impact should that have that it was part of the plea?
Your Honor, Abruzzi has determined that even if a forfeiture agreement is part of a plea agreement, as long as the court does not order it or make any determination, it's not incorporated into the judgment of conviction. So 22050 sub 6 allows it to be part of the plea agreement. However, as long as the judge is not making a determination pursuant to Penal Law 6030, it is not part of the judgment of conviction, Your Honor. Additionally, even if this court were to determine the validity of appellate's appeal, the defendant is still procedurally barred from challenging his forfeiture agreement by his valid waiver of the right to appeal. The Court of Appeals has upheld similar waivers where the colloquies were supplemented by a written waiver, and defendant confirmed that he discussed the waiver with counsel and signed it at open court. Additionally, due process does not demand that the appellant actually waive his due process protections at a court proceeding. In the cases cited, the appellant waived his due process protections by foregoing a hearing and enrolling his child in a new school. This is Boyle v. Caledonia. in Green v. Green, where the defendant was going to be sentenced to 6 months incarceration for contempt of court, he waived his due process claims by not appearing at the actual hearing.
Counsel, if we were to consider the merits of the appeal, could we find that the proceeds, the forfeiture was actually authorized, given what was recovered pursuant to a search warrant inside the apartment?
Yes, Your Honor, definitely. A 13A pre-conviction forfeiture would have been successful. There was clear and convincing evidence that the defendant committed third-degree criminal possession of a controlled substance and that he was indicted. Additionally, the money was found in the same apartment where narcotics and paraphernalia were discovered throughout the apartment. That provides a sufficient link to show that the money was either proceeds or substituted proceeds of an illegal drug operation. Additionally, Your Honors, none of defendant's arguments are preserved. This court determined in People v. Shalin that an allegation that forfeiture is illegal based on any procedural defects, which is what my adversary is alleging, does not fall into any preservation exception, which includes the preservation exception for excessive sentences. And Your Honors, if there are no further questions, I would rest on my brief. Thank you.
Thank you very much.
Your Honors, I'd just like to emphasize that the argument here isn't only that there wasn't a statutory basis. I did make that argument. But something that I don't believe was true in Appellate is I'm also arguing that the original agreement that has to happen under CPL 22050 subsection 6 between the prosecution and the defense to make something part of a plea agreement, that's what we don't have evidence here. This court did find in People v. Fergus and Challen that these forfeiture agreements must be entered into knowingly and voluntarily to be a valid part of a plea agreement. And I actually don't know that that would be able to be covered in a civil proceeding, because the question is not just would you have been able to find that this money was related to the drugs, but was it actually a valid part of the plea to begin with? That is a criminal question. It is something that's overseen by the criminal court. And what the people are basically arguing here is that someone can forfeit their right to property as part of a plea agreement, and no court has to make sure that they actually knew what they were doing.
Thank you.
And so the rest of my briefs, thank you.
Downing versus Solomon.
Good afternoon, Your Honors. My name is Scott Goldberg. I'm counsel for the appellants, the petitioner in the lower proceeding, the Article 78 proceeding. Your Honors, my clients purchased a property, a multifamily property, a six-family property.
So we're familiar with the actual background. I have a legal question.
Sure, please.
Having sat in the Article 7 part for an extended period of time, I'm quite familiar with Article 7 proceedings, and I'm wondering why this would not have to be brought as an Article 7 proceeding on the ground that it's challenging a classification.
Sure. So Real Property Tax Law 700 sub 1 governs tax certiorari proceedings, and it specifically provides that unless otherwise provided by law, a proceeding should be brought before a tax commission proceeding. This is not a valuation case. This is
You've tried to put it as a clerical error, but I'd like you to explain why this is a clerical error rather than an alleged misclassification, because you're arguing it should have been classified as one type of building, and it was instead classified as another type of building, which is a classic Article 7 type of proceeding rather than a clerical error. And there were people going out to investigate and making factual determinations as to its classification. So it wasn't just like a clerk misput the wrong, put down the wrong classification.
yes, but in this particular case, first, the clerical error rule that the City of New York, that the Department of Finance enacted in 2016, delineates what are clerical errors and errors in description. And one of those is under 19 rules of the City of New York, 53-02B9, says if a property is assessed at the incorrect number of units, that's an error that the Department of Finance will correct. And the Department of Finance needs the power to correct those mistakes because there are errors that happen.
This wasn't just like, oh, there are 4 apartments rather than 5 apartments. It's a detailed, fact-ridden determination when the building actually goes from being a multi-use building to a single-use building. It's not just a matter of we didn't count the number of apartments.
Right, I understand that, but in this particular case, the assessor actually came down to the property in December of 2016, and by the time, and came down also in January 2017 before the taxable status date for the 2017-18 tax year, fiscal 18, and
Wasn't he denied access? I mean, wasn't that one of the reasons why he refused to reconsider the classification was because he was denied access during the relevant time period?
it's unclear if he was denied access or not. I know
That's
there's,
what he stated,
there is
that
a
he was
reference, but at that point in time, the assessor decided to add two things. One, a complete demolition. He added a negative physical increase for the demolition that took place. That's set forth in the Notice of Property Value dated January 15th, 2017, with the record page 70 and 71. And he also issued an alteration, a physical improvement for work that was done, and he netted that to $265,000. Now, if an assessor decides he wants to issue a physical increase on a property, there was a building permit filed in November 2015 to erect a one-family home at this property, he must change the tax class from tax class 2 to tax class 1 because the assessment ratio of tax class 2 is 45%. So him issuing a $265,000 market value increase rendered an assessed value increase of over $100,000.
But it seems to me that your argument shows that it was a discretionary act and not just a ministerial error that could be corrected simply.
Well, it's really not because the assessment ratio shows if an assessor decides he wants to issue a physical increase when a property tax class is changing, when its use is changing, he must change a tax class. A tax class 1 is assessed at 6% of the market value. So the assessed value should have increased in this case $20,000 approximately. Instead, the assessed value increased 45% of $265,000.
The use change requires more than just on paper, right? I mean, you have to look at physical change too, right?
So Section 302(1) of the Real Property Tax Law says annually the Department of Finance has to assess a property according to its condition on that date.
Right.
What did the Department of Finance decision say in this case? We only change the tax class when the work is completed or if a C of O is issued. Just as an example, we gave 10 examples of properties, all of which underwent renovation.
Is that contrary to what they've done in the past? Is that something that's new that they've done?
No,
in your case?
that standard is not a standard they've ever applied in the past. What we gave 10 examples in our brief, in our underlying proceeding, where Department of Finance changed the tax class for properties that had undergone a renovation from tax class 2 or 4 to tax class 1.
Isn't that inherently, which has been asked already, a factual determination? How much work has been done? How far has the work progressed? And has it progressed to the point that would allow?
It is, but he felt enough to change to issue a physical increase.
That's your main, okay. Well, look, you respond on rebuttal.
Thank you.
May it please the court, Attorney Joseph Craning appearing on behalf of the City of New York. Your Honors, we're here today to ask this court to affirm the lower court ruling, which held
Why
that.
don't you respond to what his primary argument seems to be about the amount being raised of the assessment?
Sure. It's clearly, we must acknowledge first that the city prevailed in the lower court on the merits, but of course it's our contention that we never should have reached the point of deciding this matter on the merits. We should have prevailed procedurally. That is, dovetailing with Your Honor, is this
That
should
it should
be.
have been an Article 7 proceeding.
It should have been an Article 7 proceeding, not an Article.
Why couldn't it be characterized as an error in classification or an error in description?
Specifically because this was a discretionary determination. And we know that from the law, the case law, and the history that a clerical error refers to something more in the line of an inadvertent ministerial mistake, a mathematical error, an error in transcription, an incorrect transcription. Here, we have, as you noted, we have a discretionary determination. This is not an error resulting from a minor mistake or some kind of error in writing. This is an error in reasoning or judgment. And this is how we distinguish the Better World case that petitioner relies on here. In the Better World, there was no discretion at issue. As you noted, the issue there was, is this a 2-unit building or is this a 4-unit building? And even the dissent in that case noted that the error could have started as a clerical error. It's just that it ended up affecting valuation. But truly, even the petitioner in this case does not dispute, that does not contend that this was a clerical error in the form of an incorrect entry or a mathematical error.
No, but he's arguing we should have a much broader interpretation of an error, a clerical error.
Absolutely. Petitioner is alleging that finance made an error in reasoning or judgment, and somehow this is turned into a clerical error. It's just not the case, specifically because it was a discretionary determination.
Thank you.
Thanks.
First, regarding Article 7, this issue, this defense was never invoked at the administrative level. And Court of Appeals precedents in our brief, pages 9, 12, and 13 of our reply brief, after it was raised, it is well settled, it is a settled rule that judicial review of administrative determination is limited to the grounds invoked by the agency. The agency, Department of Finance, gave two rationale for denying the request to reclassify this property. One, that the work was not completed, and two, that a C of O was not issued. That is not the standard under RPTL 302. 302 says you need to assess a property based upon its condition on the taxable status state. Here, that was clearly a property that was a one-family under construction.
Oh, wait, saying
that's
that
what
the
they-
work was not completed, isn't that the same as assessing its condition on that date?
No, just
What
as
they were
we-
saying is the work isn't completed, therefore it's not yet a one-family.
No, but if you take, just an example, vacant land. You have a property, parcel of vacant land, and you're building a 30-story building. You could just put a foundation in the ground. The Department of Finance is going to change the tax class of that property to whatever property is being built, even though it's not completed.
I don't know if that's the case, but here that they clearly weren't going to do it until it actually was converted into one family, which is why they said it's not a one-family yet.
Your Honor, with all due respect, that's not the law. The law is at that time. It doesn't have to be completed. A C of O doesn't have to be issued. It has to just, even in this case, on January 5th, 2018, the Department of Finance changed the tax class to tax class 1, even though a C of O was issued in June of 2018, well after the taxable status.
Counselor, I got to ask you a question. You just said something that just caught my attention. You said, did you commence this Article 78 to restrict the kind of arguments that the city would be able to raise? Because you're saying in Article 7, they'd be able to raise all these other issues, but in this Article 78, they're raising issues that aren't allowable or shouldn't have been raised. Did you commence Article 78 to restrict how they could argue or protect or respond to your case?
No, absolutely not. Maybe I wasn't.
Oh, because it sounded like you did that.
Let me explain what I meant. The Court of Appeals has said that when you bring an administrative proceeding, whatever is invoked at the administrative level, that's what can be used in an Article 78 proceeding when you're seeking judicial review of that. Here, a new rationale is being introduced by the law department that was not introduced for the administrative level.
Thank you.
Administration. Thank you very much.
Dubrino versus Rockefeller Center.
Good afternoon, Your Honors. John Kalin for the appellant defendant, Dow Electric. May it please the court, the findings against Dow Electric in this case with regards to the Labor Law 200 common law negligence and the contractual indemnification finding against Dow rest basically entirely on the lower court's mistaken finding that the ladder that the plaintiff was using at the time of his accident was unsafe. Not only is there no evidence in the record that the ladder was unsafe, all of the evidence in the record indicates that there was nothing wrong with the ladder at the time of the accident. The plaintiff himself testified that there was nothing.
What evidence was there as to when Dow had inspected the ladder before the accident occurred?
Dow?
Yes. It was
There's-
the
there's-
owner of the ladder, right?
Correct.
So
There is general
was
evidence
there any
that they-
evidence that it had inspected the ladder at any time before the accident occurred?
Not that specific ladder, but there is testimony that it was part of their custom and practice to inspect their ladders on a daily basis. But the plaintiff himself testified that he inspected the ladder before he used it, and he didn't see any issues with it. His co-worker, Mr. Teague, who was working with him, also did not see any issues with the ladder. All of the accident reports generated after the accident found that there were no defects with the ladder. The only thing the lower court seemed to be resting its finding on is a photograph taken more than a year after the accident, and the assertion in the plaintiff's affirmation in opposition to Dow's motion that this bend in the non-stepping rung somehow made the ladder unstable and led to its fall. An argument, by the way, that the plaintiff did not even raise in its own motion for summary judgment. So I can't speak for the lower court, but I don't know where they came up with the conclusion that the ladder itself was unsafe, as there was no evidence in the record to.
Mr. Ryan, one of the Dow employees, was the one in charge of inspecting the ladders at the end of every shift and in the morning to make sure that they were in proper working order?
I believe so, yes.
And when he inspected the ladders, and if he found that the ladder was somehow defective, he would put some blue tape on it to make sure that, and remove the ladder, or at least he put the tape on it to make sure that Dow workers knew that this was not the type of ladder that they should be using?
Correct, and he would also take it out of service when he.
And this particular ladder that was used by this Mr. DeBrino on the date of the incident, that's the same ladder that was captured in the photograph where he's lying on the ground and there's a ladder standing up?
I believe so, yes, Your Honor.
And that ladder has blue tape on it?
I don't recall that, but if Your Honor says it did, then it did, yes.
If you look at the record at 467, and in some of the other photographs, you see a ladder standing up with blue tape on it, would that be an indication that that ladder was somehow found to be defective and should have been taken out of circulation by DAL?
No, it wouldn't, Your Honor, because the ladder was inspected by the person who used it, which I might add, he used it without permission, and there's no testimony to support that this specific ladder was unsafe at the time of the plaintiff's accident.
Would the plaintiff here, Mr. DeBrino, know that a ladder that has blue tape on it that was placed there by someone from possibly Dow, maybe Mr. Ryan, that meant that that ladder was not adequate for use?
I don't know if that's necessarily the case, Your Honor, but Mr. DeBrino did testify that he inspected the ladder before he used it.
Did Mr. Ryan, I'm sorry to interrupt, counsel, did Mr. Ryan say how he placed the blue tape on the ladders when he wanted to take them out of service?
I don't specifically.
Blue tape is obviously kind of a ubiquitous element in construction sites. So in the picture on 467, they're all along the steps in the ladder. Did Mr. Ryan discuss how he would apply the blue tape, if you recall?
Well, to my knowledge, Your Honor, there's no evidence that Mr. Ryan placed blue tape on this ladder. We don't know when blue tape was placed on this ladder.
But he had that practice, as Judge Mendez said.
He did have that practice, but Mr. DeBrino, who has been working in construction for many years, also had the practice of inspecting the ladders before he used them, used that ladder for 15 minutes, and found nothing wrong with the ladder, as did all of the people, including his coworkers, that inspected the ladder shortly after the accident.
Thank you. Maybe during the other people's time, you could take a look at his deposition testimony, because it seems like you're not completely familiar with what he did or didn't testify. But anyway, let's hear from the other side.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. Yes, at 467, that photograph does show blue tape, and Mr. Ryan, and at 1291, it was also discussed that blue painter's tape was on the top 3 rungs. Nobody knew why it was on there. Nobody knew how it was
Didn't he
applied.
actually testify in the deposition that he never didn't see that blue tape? That's not the way he put the blue tape on, and he would not have put blue tape on that way, and he doesn't know anything about that blue tape?
Yes, that was his testimony.
And do you say anything? I mean, I looked thoroughly at your brief, and I don't see any argument in your brief whatsoever making any arguments about blue tape or that the blue tape raises any issue of fact as to whether the ladder was defective. Like, did you make that argument at all in your briefs?
I'm not sure if the word blue tape appears in my brief, in our respondent's brief. I believe it appears in the papers below in the record that it's in plaintiff's.
Is that one of the, I mean, what evidence is there in the record, and what is the basis for your argument that there's any admissible evidence that there was anything wrong with the ladder at the time of the accident as opposed to a picture a year later? What evidence can you point to support a factual issue as to a defective condition in the ladder? And I understand 240 is different than 200, I mean, different than common law negligence. So for purposes of common law negligence, where there's no duty that Dahl had with respect to this plaintiff, what's the evidence of a defect?
The evidence that we have is that Dahl, there was a question of fact as to whether they affirmatively were negligent in launching an instrument of harm and placing the ladder in that
What's
space.
the evidence that the ladder, anything was wrong with the ladder? For it to be an instrument of harm, you have to have admissible evidence that something was defective about the ladder at the time it was placed.
The photographs at 802 to 804 of the record that showed the bend, that's
a year later.
That was at the inspection, correct. However,
So that was a year later. That's absolutely, where is the evidence in the record that at the time of the accident there was anything wrong with the ladder?
well, the defendant, whose burden it is on summary judgment, didn't establish that the ladder wasn't defective on that day. What they said was they inspected the ladder. Mr. Sheehan says, I looked at the ladder. I didn't see anything defective. But there's no evidence as to what he did with regard to inspecting the ladder. Then 30 minutes after the accident, or within 30 minutes to an hour, JRM then takes the ladder and puts it away.
Let me give you a hypothetical just to see what you'd say. Let's say you have a ladder at the premises and you're not there for 3 months. And your workers are not there for 3 months. Do you have to go in every day and inspect the ladder every day in the event that other workers may use a ladder even if you don't have any contractual duty to supply ladders to other workers at the site?
No, but this ladder was provided by Dahl should have been provided. The ladder that was there and set up was Dahl's ladder, and Dahl was working in that area. That ladder was then taken and put away by JRM, and there's no evidence in this record, and the defendant didn't provide any evidence that the ladder was then taken out of being put away and preserved in the 11 months from the date of the accident to the date of inspection. So if you want to look at it as circumstantial evidence, which can be just as good as direct evidence, there's no evidence showing that bend in the ladder wasn't there because the ladder was taken out of the site and put away until the inspection. And
Are you familiar with the case of Ramos versus Pet Market?
Not off the top of my head now.
Okay, I want to ask you about it. I won't be on the spot and ask you about it then.
Oh, okay, but our position is that the question of fact exists because this ladder was placed and set up in an area where Dahl was working, where plaintiff was working, and that forget the 240 issue. With regard to 200 and common law negligence, there's an issue of fact because even as you pointed out before, the Dahl witnesses Abdillah, and also Dahl witnesses Ryan testified that if they had seen the ladder in this condition, they would have taken it out of service. They would have never used it. Nobody knows why it was taped up. And
So you're basically saying you're relying on the picture, the evidence that a year later something was wrong with it, and that is your evidence you're relying on
That's
to show.
circumstantial evidence because there's no evidence and nobody's disputed that this ladder was in a different condition at the time of the inspection.
Other
Yes,
than that.
I also would ask you to look at the record because I believe the issue of the blue tape was briefed in the papers before the trial court. I don't believe it's in the respondent's brief. I also would like to just end before my time is up is that the issue as to whether the Dahl created the condition and launched an instrument of harm on its defendant's burden. And so they didn't establish that there was no defect in this ladder at the time of the incident. All they testified to.
No, you've stated your.
Okay. I didn't address 240, but.
It's okay. Time's up, so.
Okay.
But
Thank you.
We've read the briefs.
Okay. Thank you.
May it please the court, Sophia Uvadev for defendants, respondents, Rockefeller and JRM Construction. I'm going to limit my discussion purely to the grant of contractual indemnity.
Let me ask
the
you
lower
something,
court.
because isn't the issue of indemnity somewhat dependent on whether or not there's any liability for negligence? I know you say you don't need to address negligence, but if there's no negligence and they didn't launch an instrument of harm, how could it have risen out of their work?
Sure. So we have 3 different indemnity provisions in this contract between JRM and DAL. One's in Article 6, the other one's Article 10, and the last one's Exhibit F to the purchase order, Article 12. Not a single one of them require a negligence trigger, and this court always differentiates for the past 20-plus years between an indemnity that requires a negligence trigger versus a broader indemnity that is merely arising.
Okay, so let me ask you, if there's no contractual obligation on the part of DAL to provide ladders, which is not in this case, unlike the case with the scaffold, which I know that you place a lot of reliance on, where in that case it was actually a contractual obligation for that defendant to provide the scaffolding for the site. But in this case, there was no contractual obligation for DAL to provide ladders for other workers or other trades. Where then is the obligation? How does it arise out of their work if they didn't have any obligation under their contract to provide the ladders?
So we would, however, contest that there is no obligation to provide ladders under their contract, because we cite to Article 610.5 that says as part of their work to do the electrical work that involved working at a height, they have to provide their own equipment, which included ladders, and all of their
It doesn't
witnesses.
say anything about providing it to other trades working at the site.
No, correct. It doesn't say that. However, their witnesses did testify that the DAL policy, or the DAL policy, was to then lock up the ladders so that others don't use them. That did not happen on the day of the accident. They were left
That
in an
also
open
doesn't
shared
go
space.
to an obligation to provide ladders. You're saying maybe they shouldn't have let the other ladders have access to it, but where in the contract does it say that they have any contractual obligation, which was the linchpin of the case you're primarily relying on?
Well, in Urbina, it also doesn't say that you have to provide scaffolds for everybody. The language
Wasn't that the heart of the decision, that they did have an obligation to provide scaffolding for the site, not just for their own workers, and that was why liability was being imposed?
the language in
And that's how
Urbina,
they distinguish Greco, by saying, unlike the other case, here there was a contractual obligation.
merely says furnish, install all materials, equipment, personnel, tools, scaffolds, layout markers, and benchmarks. So this was part of the general to furnish all the tools, the personnel, and
But for
everything
all
that's
workers,
necessary.
not just their own workers, right?
No, not for, it was part of the contract. It didn't say, like, you are contracted to provide all coverings for holes, or you are the scaffold contractor. In Urbina, the contractor was a drywall contractor. So their job wasn't to actually go around and provide equipment. This was part of the very general contract terms, just like we have here, saying you have to provide personnel and equipment for your personnel. So it is analogous, but I don't even think the court has to go there, because as I mentioned, there's 3 indemnity, and we raised all 3 indemnity provisions below. The Supreme Court granted it under Article 610, but if the court looks under Article 10.1, that provision is even broader, and it is actually triggered in any case where the injury is caused or alleged to be caused in whole or in part by a violation of any law, ordinance, or regulation, or any claim of strict liability. Here, whether you believe that there was any negligence on the part of DAL, it is undisputed that plaintiff has brought a complaint alleging that DAL violated a law, ordinance, or regulation, namely Labor Law 200, 240, and 241.6. What ultimately happens with those claims is immaterial for the point of construing the indemnity provision that these 2 very sophisticated parties entered into according to the plain meaning of the language. This court has, along with the Second Department, upheld these in DePerna, Scarrett, and Sand.
Thank you.
Thank you.
Just real quick, Your Honors. I think the counsel for JRM just completely misapplied or misstated what Urbina says. That Urbina specifically says that the party that was obligated to indemnify was obligated under the contract to construct the scaffolds that the plaintiff was working on at the time of the accident. And the accident certainly, in that case, arose out of that work because the scaffold collapsed.
What about her argument that the indemnification clause is so broad that it covers situations where there's even an allegation that Dow is responsible?
Well, I would point out, Your Honors, that even though all the underlying papers had all these different indemnification clauses in the contract, only one can apply, and the one that the court felt was applicable, that was the one that was cited in the lower court's decision, where it says that they are obligated to indemnify to the extent caused by the conduct or failure to act by the subcontractor. And again, I don't want to go around it again, but there's no evidence that that Mr. DeBrino's accident was caused by Dow's failure to act or its conduct.
And what about the evidence about the ladder, the damage to the rung in the ladder that was discovered after the fact?
The photograph of the ladder was taken more than a year after the accident occurred. According to case law, Melendez, if the photograph is going to be used to support a finding that the ladder was damaged at the time of the accident, the photograph has to be taken in a contemporaneous time, and there needs to be testimony saying this is what the ladder looked like at the time of the accident. And there's
said that it was put away and out of use from the time of the accident until the photograph was taken.
well, the record will show that at some point later in the day after the accident occurred, JRM broke a chain and confiscated the ladder from DIL and took it into its own custody, and then it was under the exclusive control of JRM until these experts were allowed to inspect it. And I would point out that all parties in this case had an expert. We had an expert affidavit saying
Okay, your
that.
time's up. I was going
All
to
right.
let you respond to the question. Thank you very much.
Thank you, Your Honor.
People versus Bartley?
Sylvia Laura Altruder of the Legal Aid Society on behalf of the appellant, Colin Bartley. Colin Bartley's aggregate sentence of 4.5 to 9 years of imprisonment is unduly harsh and excessive and should be reduced to 3 to 6 years. First, his 1.5 to 3 year sentence for second-degree bail jumping should run concurrently rather than consecutively with his underlying sentence. The applicable statute calls for bail.
Did he make that argument below?
No, Your Honor.
So can we consider it?
The argument is a challenge to the excessiveness of his sentence, which can be raised on appeal. The applicable statute calls for bail jumping sentences to run consecutively in many situations, but not in Mr. Bartley's. Sentences may run concurrently when there exist mitigating circumstances that bear directly upon the manner in which the crime was committed. Such circumstances exist here. Mr. Bartley is an Army veteran, and after he was arrested in 2018 after a shoplifting incident, he was accepted into Veterans Treatment Court. As part of his participation in that court, he pleaded guilty and agreed to participate in—
His veteran status was known to the judge who sentenced him, correct?
Correct. He agreed to participate in programming. He, however, struggled in his program, and after he missed a court appearance, a warrant was issued for arrest. These constitute mitigating circumstances.
He has a history of violating bench warrants, right? Or having bench warrants issued, 15 or so?
Yes, Your Honor. Mr. Bartley was not accused. So the Court of Appeals has set forth a standard in People v. Garcia under a similar provision of the same sentencing statute that describes mitigating circumstances as the absence of a weapon and the lack of violence. Both of those are present here. Mr. Bartley has never been accused of anything violent. He was also There were no accusations that anything he did involved a weapon. He was also in as opposed to a traditional court, he was in a specialized treatment court where he was there to get help and get a second chance. The drafters of the statute setting forth the standard regarding mitigating circumstances talk about fears that people who jump bail will erode the prosecution's ability to prosecute the cases against them. They fear that people will go after witnesses or try to just tamper with witnesses or destroy evidence and somehow. Those concerns do not apply here where Mr. Bartley had already pleaded guilty, which meant that there was the prosecution's ability to prosecute him. As we can see, we're unblemished by his failure to appear. And again, he had no record of violence and no history of violence in this case. Second, his 3.5 to 7 year sentence under the other indictments which represent the maximum sentence he could have received, are unduly harsh and excessive. For one, many of these crimes were crimes of poverty. For example, 2 of his convictions involve him passing a bad check to get a root canal and a dental cleaning. They were also excessive given that he pleaded guilty in December of 2019. He was sentenced in January of 2020. What everyone understood his incarceration would look like in January of 2020 was very different than what it ultimately was. He was incarcerated during COVID. He was upstate in March of 2020, and he describes it was total chaos when he was in. Visits were suspended, programming was suspended. He's a spiritual person, and his religious services were also suspended. He's close with his family. No one was able to visit him. In light of...
Thank you. You'll have time for rebuttal.
Good afternoon, Your Honors. May it please the Court. Nathan Morganti on behalf of the people. The court below properly sentenced the defendant, and that sentence should not be disturbed. Defendant's waiver was valid and foreclosed his current appeal, and he failed to preserve his arguments regarding his bail-jumping sentence. Additionally, defendant's sentence was not just proper, but in fact lenient, as he effectively received additional time only for the bail-jumping and no time at all for his instant fraudulent schemes.
He pleaded guilty to 9 counts, of course, 3 indictments, right?
Yes, Your Honor.
All right.
Yes, Your Honor. And actually, other than the bail-jumping sentence, all defendants' sentences were run concurrently to a pre-existing 3 to 6 year sentence that he received on that earlier charge that led to the bail-jumping charge. What defendant would actually serve here was not the 7 years, but instead only 1.5 to 3 years on these additional new charges. And now he argues that even that little bit of time is excessive. It's important to understand exactly how this plea deal structured out, where the defendant was already sentenced to those 3 to 6 years. On his instant crimes, he received 3.5 to 7 years, run concurrent to those sentences. So his real sentence on those crimes was actually only an additional half year to 1 year. When we add in the bail-jumping sentence, that bail-jumping sentence was run consecutive to that 3 to 6 year sentence, and so the entirety of those new sentences were subsumed into that original sentence plus the bail-jumping sentence. This already is lenient, and the fact that the defendant was already out in Veterans Treatment Court and had already received leniency is important to understand. If Your Honors have no questions, we ask that this court affirm defendant's convictions and uphold the sentence he agreed to in exchange for his guilty plea, and we rest on our brief.
Thank you.
Thank you.
I'm going to briefly respond. 1.5 to 3 additional years incarceration is not a little bit of time. It is not particularly lenient. He received the maximum sentence under indictments 3499 and 3282.
You're saying he received the maximum sentence on the counts that he pled guilty to?
Correct.
There were many, he pled guilty to maybe less than a quarter of the counts that were charged, right?
He pleaded, the top counts in each indictment was a D felony. He pleaded to a D felony in each case. The maximum sentence he could have received was 10 to 20 years, which I think gets at your question, but 4.5 to 9 years is still, it's a long time. This represents the longest time he will ever have been incarcerated. He has a family, he has 2 children. He is very conscious of the fact that he's missed out on a significant part of their life. He's missed out on a lot of things happening in his family. His mother passed away while he was incarcerated, and he was very eager to get back to them. Thank you, Your Honor.
Hartree Partners versus Vaquero.
Good afternoon, Your Honors. Elliot McGraw on behalf of Appellant. I respectfully request that my colleague Josh Hammock, who's been admitted pro hoc vice, be permitted to participate here today.
Permission is granted.
Good afternoon, Your Honors, and may it please the Court. I'm Joshua Hammock on behalf of Vaquero. We're here today to talk about what's known in this case as the buyback agreement. Recall, however, that there are 3 agreements here that form a single integrated contract. The base contract contains general terms including the force majeure provision at issue in the case. Second, the October 2019 transaction confirmation establishes that Vaquero will deliver to Hartree 50,000 MMBTU of natural gas.
I want to ask you about some specific language and how we deal with that language. And that's in the primary contract 11.5, which is part of the force majeure provision. And it says, upon providing written notice to the other party, the affected party will be relieved of its obligation to make or accept delivery of gas. How do we deal with that in the context of the buyback agreement? Because neither side really disputes that the way the buyback agreement works is that you never have to deliver or accept that gas. It's a buyback, it's a financial arrangement. So why doesn't this language, which makes specific reference to make or accept delivery of gas, basically have a carve-out then for the buyout agreement in terms of applying that provision?
It doesn't have a carve-out for the buyback agreement, Your Honors, which is our 3rd agreement in this case, part of the single integrated contract. Because again, remember Mr. Martinez's testimony, the Hartree trader who negotiated the buyback agreement. For agreements like that, delivery is accomplished via netting. It's not a physical delivery of a volume of gas, but there still is delivery via netting. So the obligation to make or accept delivery of gas still can be relieved by that force majeure language.
No, but netting is essentially a bookkeeping function. It doesn't involve, it wouldn't be impaired by any storm.
I disagree in one respect, Your Honor. I think one way to think about the agreements and the buyback agreement in particular is that it's written exactly like the October 2019 transaction confirmation with a delivery address, with a delivery time period. So strictly speaking, the literal language of the agreement is written as if there would be a 50,000 MMBTU delivery from Vaquero to Hartree and then a 15,000 MMBTU
But isn't it
delivery back.
undisputed realistically that once that buyback agreement is entered into, the obligation, the contractual obligation is only to deliver 35,000 and not 50,000?
No, Your
There's
Honor.
no,
Not-
what is the legal obligation to deliver the remaining 15,000?
Because, and that's the primary point in this case, is to consider what exactly Vaquero was buying back. And it was buying back a portion of its own delivery obligation. You see that throughout the case. Hartree has repeatedly confirmed that the buyback agreement concerned only the volume Vaquero was otherwise obligated or otherwise required to deliver. It's in their briefs in both courts.
Doesn't that mean that you don't have to deliver that amount of gas to Hartree?
I'm sorry, Your Honor, I didn't quite understand.
Doesn't that mean that you don't have to physically deliver that amount of gas to Hartree?
The amount that you,
The 15,000.
the amount that you took the buyback for.
Because of netting, the physical delivery is not occurring, but the
Precisely.
delivery in a contractual sense is occurring via the netting. That's the way the deal is understood. And again, the way to think about it is that the transaction is happening instantaneously. A delivery of 50 is going one way and a delivery of 15 is coming back at the same time.
So that sounds a lot more like what Justice Moulton said, that this is only a bookkeeping transaction. In the books of Hartree, it'll say they purchased 15,000 units from us, and therefore they have to pay us 15,000 units because Hartree doesn't have to deliver any units to you. You're the only one that has to deliver to Hartree.
I disagree that it's just a bookkeeping transaction in the sense that the trial court
The
said.
agreements mirror, you're saying that the two agreements mirror each other, the language, so that the force majeure would have to apply. It's not just simply a bookkeeping, right?
Absolutely, and there's a volumetric netting that occurs alongside of the financial obligations Your Honor was referring to a moment ago. Those two pieces have to occur together. It doesn't make sense to separate them, and if I could jump to an analogy here.
Before you jump to the analogy, I have a question about another clause of the contract.
Okay.
The last sentence of 11.2, seller and buyer shall make reasonable efforts to avoid the adverse impacts of a force majeure and to resolve the event or occurrence once it has occurred. And what do you understand Vaquero's obligations to be under that provision of the contract?
I think Vaquero's obligation is to anticipate when an event might interrupt its performance of an obligation in the contract and to take prompt action to limit the effects of that interruption. And that's exactly what Vaquero did in entering the buyback agreement. But again, the way the parties handled that did not affect either party's ability to rely on the base contract's force majeure language. So that, I think, is the critical piece. The force majeure language applies to the October 2019 transaction confirmation. It applies just the same way to the obligations contained in the buyback agreement, which were contingently linked, even according to Mr. Martinez's, Hartree's witnesses' testimony in the case. If I can turn to that analogy really quickly, Your Honors, I think it helps if you think you walk into a convenience store to grab a Gatorade. Let's assume it's $10. I go to the cashier with $20 in one hand and my Gatorade in the other.
I'll let you finish this quickly.
Oh, thank you, Your Honor. And I ask, if I give you this 20 for this Gatorade, you'll give me 10 back, right? The cashier says, yes. I have second thoughts, put the Gatorade down, put the 20 in my pocket, and hold out my hand and say, well, give me the $10 back. That's effectively what Hartree is arguing in this case.
Thank
It
you.
wants the $10 back without the 20. Thank you, Your Honors.
Good afternoon, Your Honors. Robert Mantell from Crowell & Mooring on behalf of Respondent Hartree Partners, LP. Your Honors, Vaquero should be held. Yes, Your Honor.
Question. It seems to me that your argument is essentially that the buyback agreement eliminated Vaquero's ability to invoke a force majeure. Can you show me, is that correct? Is that part of it?
No, Your Honor, I wouldn't say that.
So why couldn't it invoke force majeure and not have, and be entirely relieved of its obligation to provide any gas to you in February 14th to 16th?
So Vaquero was still obligated to deliver 35,000 MMBTU between those days. We don't dispute that they were.
But once they declared force majeure, why didn't that relieve them of that obligation?
It did. It relieved them of the obligation to deliver the 35,000 MMBTU that they were still obligated to deliver. However, New York law is clear on how force majeure applies. It only applies to excuse a party from obligations that themselves were prevented by that event. Here, the only obligation under the buyback, which is what's relevant here, not the underlying delivery of the 35,000, but the 15,000 that Hartree had bought back from them, they weren't prevented from performing under that buyback agreement. All that was required, Justice Moulton is entirely correct, it was financially settling the buyback in the parties' invoices. That was not prevented by Winter Storm Uri.
They were relieved of the obligation to provide the additional, to actually deliver any natural gas at that point, correct?
So they were previously obligated, before they entered into the buyback, to deliver 50,000 MMBTU of natural gas each day, subject to that prior agreement. Prior to the force majeure event occurring on February 12th, they agreed in advance, well, actually, Vaquero's trader reached out, and I want to be very clear about what actually the contract is here. The contract is that ICE chat on page 313 of the record. There's no dispute that that's the agreement. That's what formed the agreement. In that ICE chat, Vaquero's trader reached out and said, we want to buy back 15,000 MMBTU. They agreed upon a price, specifically because they wanted to reduce their delivery obligation during those days.
They still had to deliver 35.
That meant that they were just, at that point in time, going forward to those 4 days subject to the buyback.
And then they invoked force majeure.
And they invoked force majeure on both the 35,000 they were still supposed to deliver and on the buyback, meaning, yes, we can't deliver the 35, and you know what? We're just going to cancel that buyback we made. We don't have to pay you for that gas anymore. But that's what they couldn't do, because there's no legal basis, there's no factual basis for them doing so.
You're not disputing their right to be relieved of the obligation to supply the 35?
No, Your Honor.
And what about as to the 2 following days?
So there were 4 days subject to the buyback.
3 more days, sorry.
There were 4 days subject. The first day operated the way it was supposed to. The next 3 days, they canceled the buyback on all 3 days. So all
You're
3
saying
days.
because, just so I understand, because their inability to, their ability to perform or not perform under the buyback agreement had nothing to do with the weather or any conditions that would allow them to invoke that clause, the force majeure clause.
Precisely. Their force majeure only is a narrow doctrine that is applied.
You're not even really relying on the specific language of the agreement. You're saying that under this, what force majeure means, which is that, you know, that type of condition, and that's not true for the amount under the buyback.
Well, we're relying on the agreement just for the purposes of responding to their, feigned disputes of fact as to how this agreement was supposed to operate.
So what's your response to the argument that I heard that the two agreements, that are at play here, the mirrored languages which allows them, which they're arguing allows them to use force majeure for the 15,000 buyback?
I understand, Your Honor. First, just to be very clear, I think what counsel for appellant is referring to is the trade confirmation that follows subsequent to the force majeure event occurring. The contract is the ICE chat. That's what forms the agreement. Counsel didn't mention that. That agreement is very clear as to how this works. Vaquero's trader reaches out and says, we're going to have reductions in gas. We want to lower our obligation.
Right, but ultimately, I'm not, but in terms of the actual language that's being employed here, which they're arguing, at least I think they're arguing, is that it at least triggers, it creates for them, they're saying that they're allowed to use the force majeure for this 15,000.
In appellant's opening brief, they claim that they could use force majeure as an excuse for any obligation anywhere in the contracts, even if that event didn't stop them from performing that obligation. So that's just not the law.
No, but okay.
So I'm saying, I agree, Your Honor, that the force majeure provision in the base contract doesn't disappear. Justice Borick in the commercial division didn't limit that force majeure provision. He got it exactly right. The event that they're saying was a force majeure event just did not excuse performance.
What if the documents, the confirmations and the other documents, the agreements, they use similar language that sort of in your mind can perhaps, you wouldn't be using certain terms if you weren't having, you wouldn't have the ability to consider a force majeure situation for it.
I understand what you're saying in terms of how this is papered. There's no dispute in the record as to how buybacks operate. There is no gas to be delivered that is subject to the buyback. Both parties, at least now, maybe not at the motion to dismiss stage, but at least now both parties agree to that. That's a pretty basic understanding of how these buybacks work. So that...
But isn't the premise of the buyback also that they could continue to provide the other 35?
It's not. There's nowhere in the agreement, in any conversations between the parties, that the buyback was contingent on Vaquero still having an obligation or the force majeure event not occurring. Vaquero entered into this agreement specifically because they anticipated reductions in gas. What happened? There were reductions in gas, just more than Vaquero had anticipated. They're a sophisticated business party. They knew what they were doing. They just regret this trade. That, under New York law, is not an excuse for performance.
Thank you. Is there any other questions? Okay, thank you very much.
Your Honors, very briefly, I just want to focus on the nature of a buyback agreement. And just the name itself kind of gives you the detail that you need to know here. Vaquero couldn't buy back something it didn't first deliver. It's the same as the analogy that I mentioned before my time cut off last time. The cashier doesn't give you $10 back.
You couldn't deliver the 35, how could you buy back 15?
If you can't deliver the underlying obligation, there's nothing left to buy back.
But the number was 50, not 35.
Correct, Your Honor.
So you were buying back 15 so that you would only have to deliver 35.
Again, Your Honor, that's true in the sense that that netting occurs instantaneously. The 35 is the same as if we sent 50 and immediately Hartree sent us 15 back. That's the way to conceptualize the deal. Without
You can conceptualize it that way, but what ends up happening at the end of the day is that there's a numbers game. There's a bookkeeping that takes place in their books where now they say we're not going to get into 15. They're paying us for the 15, which is you paying them for the 15.
I don't think the deal can be cut that way because there is no 15 in isolation. The buyback agreement necessarily depends on the underlying delivery obligation. Thank you, Your Honors.
More questions?
Oh, you have more
We
questions.
get
I'm
to
sorry.
keep asking.
Go ahead. Yeah, I'm sorry, Your Honors. Go ahead.
Go ahead.
Okay. So as I understand your argument in your papers, you're arguing that your agreement to buy back 15 was sort of pursuant to the last paragraph of last sentence of 11.2, and was kind of a good deed to anticipate the effects of the force majeure. But they argue that wasn't a good deed. It was just a good business decision to try to avoid the effects of the force majeure. How do you address that?
I don't think, I'm not sure that there's much of a difference between the two. I think it's undisputed in this case that the buyback agreement was entered anticipating the effects of Winter Storm Uri. It's also undisputed that Winter Storm Uri was far more devastating than anyone anticipated. No one disputes that Winter Storm Uri was a force majeure event. It's true that we were trying to limit the effects of a force majeure. We just weren't able to do so because it was, in fact, so devastating.
I just want to clarify one thing with the 50,000 that we talk about. Ultimately, what happens is, we have with three figures here, 50,000, 35,000, 15,000, right? Essentially, it's like if they give you back 15, it's 35 to them, right? That's the 50. It's always been 50, but how you set this all up, I get back to 15, they ultimately get 35 delivered.
I think that's right, Your Honor.
And at this moment, the point you're making is like the Gatorade situation is like, I never gave you anything. So how can I buy back something I never gave you?
That's exactly right, Your Honor.
Thank you very much.
Thank you.
Castaldo.
May it please the court. My name is Barbara Sheehan. I represent the defendant appellants, Siami Construction Co., Inc., and Siami Construction, LLC. As I'm sure this court knows, this case involves an unwitnessed trip and fall accident on a ramp at a construction site in Brooklyn for the erection of the City Tech building for CUNY. It's our position on appeal that the court below erred in considering an unsworn affidavit, self-styled affidavit.
So let me ask you something. Your big argument is that the court should not have considered the court reporter's affidavit. So let's say we take that out of the equation.
Okay.
Even with that out of the equation, why would that change the result where the plaintiff corrected his own testimony? His testimony is consistent with the testimony of Siami supervisor as to the size of the ramp, and it's also consistent with the drawings associated with the ramp. So even if you take that aside, there's plenty of other evidence to support the finding the court came to.
Well, I take dispute with that, Judge, because there is a difference between whether the ramp was 7 feet wide, 12 feet wide, as the Siami superintendent basically guessed it might have been 4 years after the fact, or 15 feet wide, as counsel has now argued in his appeal to this court.
It certainly wasn't 70 feet wide, though. There's nothing to support.
There's no way it's 7 feet wide.
Nothing to support the 70 feet, right?
Right, but it does matter because we submitted an expert affidavit by a construction site expert who says that even accepting that plaintiff's testimony is accurate, that after he fell, he noticed it was 2 feet, the hose that ran, vertically up this ramp was 2 feet from the edge of the ramp. Even if that's true, if it's 15 feet wide, at least 9 feet.
Excuse me, didn't your expert rely on the, what turned out to be erroneous statement or erroneous transcription of it being 70 feet wide?
He did in part, but he also goes on to say it doesn't matter because whether it was 2 feet from the side of the ramp, it doesn't count as an obstruction. It's going vertically up the ramp, not horizontally. He describes the plaintiff's testimony that every time he had seen it, and he had seen it numerous times in the 5 weeks that he had worked at this site before this accident occurred, and every single time it was neatly coiled at the bottom of the ramp and proceeded vertically up the ramp. And under those circumstances, in addition to the fact that the plaintiff testified that he had traversed that very same ramp with that very same dolly minutes before this accident occurred, had no obstructions. He testified there was nothing wrong with the ramp. There was no debris on the ramp. There was no problem with the dolly. He went down and filled his cart, his dolly, with construction materials, and he loaded it so that on the left side of the cart, there were pipes sticking up. So now he's pushing this dolly that weighed some 200 pounds back up this ramp that he had just come down with 0 problems whatsoever. He's now standing to the right side of the dolly. And instead of standing behind it, as common sense would dictate he should have been when you're pushing a heavy dolly up a ramp, and it's only then that he somehow either tripped on something that was 2 feet out, that our expert says was not an obstruction, or he tripped because he kicked it himself because he was standing in a place where he should not have been.
Undisputed, though, there was more than one item. There were a number of items on the ramp that
On the
was
left
blocking.
side.
So why wouldn't that be a violation of the industrial code provisions?
Because those were not what was the subject of the claim here. He's saying that the tripping hazard were not the items that were on the left side of the ramp. He described those items as basically construction materials
The
that
fact
did not
that
impede
there's
his
a number of,
path.
industrial code requires a clear passageway, and the fact that there were a number of items on the ramp goes to the issue of whether or not there was a clear passageway. Although he claims he fell on the rope, the fact that there were other materials there besides, besides the hose, goes to the issue of whether or not that ramp was obstructed or not, or clear passage.
But as a matter of law, Judge, I submit to you that not as a matter of law, not given all these disputed testimony and the disputed facts as to what the actual width was, coupled with the fact that we submitted an expert affidavit that postulates the plaintiff was the sole proximate cause of this accident. Not just that he was comparatively negligent, but that he himself, knowing that this hose was there, supposedly having complained about it 5 weeks earlier, and we're not talking about him having to move.
So they're allowed, that almost sounds like they're allowed to violate the provision as long as he knows about it and he's aware there are things there. It's his duty to stay out of the way of the things that shouldn't be there in the first place? Is that?
Except the expert said that this, because it's on the side and going up the side of the ramp, it's not necessarily an obstruction. The Siami site super also testified that depending upon how far out into the ramp it proceeded, it would not have been a tripping hazard. So all these factors should be considered by a jury.
Wasn't that in part predicated on your expert's false conclusion?
sorry?
That it wasn't the fact that it wasn't your expert's conclusion that it wasn't a tripping hazard in part based on his belief that the ramp was 70 feet wide instead of somewhere between 7 and 15?
In part, yes, but he's saying
That would make a
regardless,
big
there was-
difference, wouldn't it?
In part, yes, but he also went on to say that regardless, it did not obstruct the ramp. It was only 2 feet from the edge. So that's where it plays into consideration these various dimensions that have now been thrown out. And shouldn't a jury hear that as opposed to a judge deciding as a matter of law that there is a violation? And if I can just briefly address
You're going to have to
industrial-
do that in rebuttal because you have.
All right.
time.
Went to red quickly, thank you.
Thank you, Your Honors. May it please the Court, I'm Scott Singh, and I represent the plaintiff respondent in this matter. I just want to, I'm not going to, I think the Court understands that this was not a 70-foot expressway. It was just a...
What about her argument? There's limited debris. It wasn't really an obstruction. Or at minimum, there's a question of fact as to whether the items that were on the ramp constituted an obstruction or not.
I mean, there were an obstruction, and there was also a hose that projected. Now, in the past, he said it was neatly coiled. At the time after the accident, by the way, he didn't see the hose either going down with a dolly or going up with a dolly. It was not something that you could easily see when you're pushing a dolly. But he had seen, in the past, he'd seen it neatly coiled. But afterwards, he looked, and he found it was not neatly coiled. It was projecting 2 feet into a very narrow space that he had to negotiate to get the dolly up the ramp. I mean, the hose was an obstruction, and I agree with Your Honor that the boxes and the other duct, there was ductwork boxes, 5.
No agreeing with me. I'm only asking questions.
I agree with the assumption of your question. So I just want to point out one thing. The defendants, in terms of our entitlement to summary judgment, the defendants rely on a case Masiki, which was a 2009 decision of the Court of Appeals, but they neglect to discuss the case of Rodriguez against City of New York, that I'm sure all the bench is aware of, which says even if there's a question of fact as to the plaintiff's comparative negligence, the plaintiff is still entitled to summary judgment if the facts reflect a violation of the labor law on the part of the defendant. And I noticed in in reviewing that there was in addition to Rodriguez, this court very recently, I think it was just like a few days before I wrote my brief, and I apparently didn't see it because I'd probably finished my research at that point. But this court decided a case on September 26th, Piedra against 111 West 57th Street property owners, and Justice Moulton was on the bench in that case. The court says, the evidence was sufficient to establish that the defendants violated Industrial Code 23-1.7e, as the staircase constituted a passageway and the wood created a tripping hazard within the meaning of the statute. In opposition, defendants submitted no evidence controverting plaintiff's sole account of the accident. And the court continues, any possible comparative negligence on the part of the plaintiff does not preclude liability founded upon a violation of Labor Law Section 241-6. That's Piedra against 111 West. It's 219 AD 3rd, 1235. And I think that states essentially why we believe we're entitled to summary judgment. The court didn't exactly get all the analysis correct, I have to say, because the judge recognized this was a passageway, but then the court said, well, it wasn't debris, but it doesn't have to be debris to be an obstruction, as the court knows. Any materials or tools which could cause tripping are violations of 23-1.7e1, the passageway regulation. So we believe we're entitled to summary judgment and that the judgment should be affirmed.
Thank you.
Thank you, Your Honors.
Just briefly, Your Honor. The Piedra case has a factor that's not present here, which was in that case the plaintiff actually took photographs of the alleged tripping hazard that caused him to fall. There it was an unwitnessed accident. Here it was too. There they had photos that we do not have here. And it was not even reported to my client. And they had no record of it even having occurred, so there was no way of investigating it. Even the accident report that was filled out by his employer was 2 days after this accident. And even then, it described him as going down the ramp instead of up the ramp, as he claimed at his deposition. Just briefly as to 2.181, it talks about material piles and building materials. The only thing the court below addressed was whether this was a passageway. We submit that a single hose that runs along the side of a ramp cannot, by definition, be considered either a material pile or building materials, unlike the numerous other cases which discuss sheetrock, I-beams, things along those lines, as opposed to a hose that is not going to be an integral part of the construction. Thank you very much.
Ark versus Archdiocese. Oh, and Justice Owing is recused in this matter.
Good afternoon, Trusha Goff on behalf of the appellant. May it please the court. This appeal stems from the lower court's dismissal of Loyola School in a Child Victims Act case, where the plaintiff alleges that Loyola's negligence resulted in plaintiff being sexually assaulted by his teacher.
Can you address the contention by opposing counsel that your complaint never asserts where any details as to the attempt as the alleged assault or any statements as to where it occurred?
Yes, so that level of detail is simply not required to be alleged in a complaint. This court and other courts have held that there is no specificity standard required for pleading claims of negligence, particularly in CVA actions. Even recently, this court in the ARC 357 case versus the Jesuits acknowledged again that there is no specificity required. That's precisely what a bill of particulars and discovery is for. The details of the assaults that were committed do not change the fact that defendants are alleged to be negligent.
The complaint does state it was the alleged assault took place at educational programs at Loyola, correct?
Correct. The complaint also alleges that plaintiff was a student at the school, that the alleged abuser in this case, Father John Farrand, was an employee of the school, that Loyola had custody of the plaintiff, was responsible for him as a school, that schools responsibility for the supervision of its students is well known. All of these facts give rise to the school's responsibility to protect the plaintiff from foreseeable harm. And we additionally allege that the harm to plaintiff was foreseeable, that Loyola knew or should have known of his propensity to commit harm, and specifically the harm of sexual abuse. This more than meets the notice pleading standard, and for that.
Let me ask you one follow-up question. In order to come within the protections of the extension of the statute of limitations, don't you have to allege adequate facts to show that the abuse was constituted claims under Article 130 of the penal law?
You don't, Your Honor. The statute of limitations revives all claims based on sexual abuse and describes sexual abuse as any crimes in Article 130. What the complaint in this case alleges is that there was unpermitted sexual contact. Any sexual contact between a 14-year-old, which is pled in the complaint, and an adult is illegal contact under Article 130 of the penal law. And for that reason, that meets the standard necessary to revive the claims under the Child Victims Act. The lower court also misinterpreted the case law as it relates to the nexus requirement, and this court's decision in the Waterbury versus New York City Ballet case is instructive on this point. In that case, in Waterbury, the court held that the nexus requirement is really about the relationship between the employer and the employee, giving rise to a duty to protect against foreseeable harm. And that was alleged in the complaint. The complaint states the employment relationship clearly, and that the abuse was committed while this individual was employed by defendants, and that's in the record. There's simply no case that the lower court relied on that requires the level of pleading that the lower court ultimately determined was necessary, and certainly not that counsels in favor of the drastic result of dismissal of all the claims against Loyola, and for those reasons, the lower court should be reversed. If there are no further questions, I'll rest for now and address anything further on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Gershon Ackerman, an attorney at Seyfarth Shaw, on behalf of the respondent Loyola School. This is a case, as Your Honors know, where the plaintiff appellant seeks to hold Loyola School liable in negligence, along with the other defendants, for alleged unpermitted sexual contact.
Aren't there now a long line of cases, very recent cases from the First Department, where we consistently hold that the pleading standards only knew or should have known, and that's a fairly low standard for a pleading purpose. So why was it appropriate with that standard to dismiss the complaint?
Your Honor, a few points in response. First, the lower court's decision was premised primarily upon the nexus issue, not upon the notice issue. But even with regard to the notice issue, there is a very recent case by the Court of Appeals, which is a More Charitable Foundation, a decision from June of this year. It's not a CVA case, but there the Court of Appeals discusses at length the requirements for alleging a negligent retention and negligent supervision case, a claim against an employer. In that case, there was also an underlying intentional tort. It was fraud. Here, there's an underlying intentional tort, which is alleged sexual abuse or unpermitted sexual contact. There is no distinction offered by the appellant that there should be a difference in the standard of alleging negligent retention or supervision based on what the underlying intentional tort is. And so Moore, I would submit, is directly on point where the Court of Appeals recited in several paragraphs the allegations in the complaint there where there were facts alleged, both with regard to the underlying intentional tort and the tortfeasor's acts in committing fraud, and with regard to why the employer should have been on notice based on those, on the propensity is the word I was looking for. Here, unlike Moore in that regard, there are no facts alleged in the complaint, not a single fact about a propensity by the alleged tortfeasor, Father Ferrand.
Fraud, I'm not completely familiar with that case. Wasn't the fraud in Moore not related to the work or any of the work activities, or alleged to have been related to the activities he did at his work?
I would submit that it was related to the work activities. There the defendant was a investment bank, and there was an investment banker employed by the bank that was defrauding clients through his employment.
Wasn't his claim that he was doing the defrauding acts outside of his work environment?
he was using his employment in terms of the fact that it was at work, as I recall, it was the work computer, the work paraphernalia. And so with regard to the fact that it was an underlying intentional tort, I would argue it's directly on point. But either way, I would say that the court did lay out the requirements for alleging a negligent intention, a negligent retention and negligent supervision claims against an employer, and the court didn't suffice with simply saying, this is the standard that you have to set forth facts regarding a propensity. The court elaborated, what does it mean to set forth facts regarding a propensity? And went on to recite, these are the facts that are in that complaint. There are no such facts in this complaint. And none of the decisions issued by this court, to my knowledge, have any kind of consideration of how the Court of Appeals' decision in Moore impacts this analysis. I would also like to point out, with regard to the nexus issue, that there is no dispute. This complaint simply has paltry few facts. We're told that the plaintiff was a student at Loyola School. We're told that the plaintiff sustained unpermitted sexual contact by Father Ferrand while a student at Loyola School, but we're not told where it occurred. We're not told how often it occurred. We're not even...
That sounds exactly like a bill of particulars. That's exactly the kind of things that you would amplify in a bill of particulars.
With regard to where it occurred, I would say
Notice pleading.
Excuse me, Your Honor. I would say there isn't a single fact in the complaint.
But counsel, we're a notice pleading state. I don't understand where this obligation comes from.
Even in a notice pleading, the court and the defendant have to be on notice of what the claims are. Here, there is no notice at all in the complaint of what the connection or nexus is between the alleged abuse, where we don't even know where it occurred, and any events that occurred at Loyola School, where the only events that are alleged to have occurred is the fact that the plaintiff was a student, and even with regard to the employment.
And that the father was a teacher, and that this occurred during the time that the victim was between 14 and 16, and in the course of educational activities.
The complaint, respectfully, with response to Your Honor's question earlier, it doesn't say that it occurred with regard to educational activities. In paragraph 6 of the complaint, there's a reference to educational activities. There's no nexus drawn between that and any of the abuse that occurred. It didn't occur in that regard. At least it's not alleged that way. And with regard to the employment, the complaint does this throughout, consistently conflates and groups together all the defendants. It says that Father Ferrand was employed by the Archdiocese, by the Jesuits, and by Loyola School, altogether, collectively, as if there's just some kind of collective employment. And I'd like to also briefly turn to the issue of the nature of the conduct, respectfully alleging that unpermitted sexual contact is insufficient. The decisions that this court has issued, if you look at the underlying complaints, those complaints, as compared to this, say unpermitted sexual contact and refers to specific penal sections. This complaint makes no such reference.
Sexual conduct between an adult and a minor, isn't that on its face illegal conduct?
I would say two things. First, the complaint doesn't allege unlawful contact, and if you refer to Section 130 of the penal law specifically defines what is considered unlawful sexual contact within the context of the penal law. And it specifies certain kinds of acts. Those acts are unlawful sexual contact.
Thank you.
Thank you, Your Honors.
Just briefly, as it relates to the Moore Charitable Fund case, one important factor, and again, that was not a Child Victims Act case, but in that case, the court explicitly said, and this relates to the same standard that this court applied in the GT versus Roman Catholic Diocese of Brooklyn case, evidence of exactly what defendants knew and when is primarily within their sole possession and control. It's simply not the case that this is required to be pled in a complaint. Here, where the complaint's alleged that they knew or should have known of the dangerous propensities of this individual, and that's in the record, that is sufficient to meet New York's pleading standard. As it relates to unlawful conduct and whether or not plaintiff pled unlawful, unlawful is not the word used in the complaint. Any sexual contact, again, between a 14 to 16-year-old and an adult is unlawful by the very nature of it. And so the allegation that there was sexual contact sufficiently puts the defendants on notice of the claims against them. It is a claim for negligence based on underlying sexual assault by one of its employees.
The argument that defense attorney makes as to the when, where, and how, is that something that should have been in the complaint or something that can be remedied through a bill of particulars?
It absolutely is not required to be pled in complaints. That's precisely the purpose of a bill of particulars, to amplify the pleading. And additional details always become apparent throughout the course of discovery. There's simply no case that the lower court relies upon that would counsel in favor of that kind of requirement at a pleading stage.
Thank you.
Thank you.
People versus Castro?
Good afternoon, and may it please the court. I'm Jihan Rim with the Legal Aid Society, representing appellant Mr. Jose Castro. This is a case where the Board of Examiners of Sex Offenders correctly assessed Mr. Castro's risk level at a low end of a risk level 2 with just 80 points. There were no overrides or designations. The board did not recommend an upward departure, and this was Mr. Castro's first instance experience with the criminal justice system altogether. This was not someone who the board assessed as posing the highest level of risk to public safety, and this was not a case where a level 3 adjudication was warranted. The risk assessment instrument correctly assessed Mr. Castro's risk level, and the totality of the circumstances did not warrant an upward departure. So today we're asking this court to adjudicate Mr. Castro a level.
The most troubling part, counsel, I'm sure you know, is the relationship with an actual 12-year-old, which morphed into a BDSM kind of thing, sadomasochism. And so given that, on top of thousands of images of child porn, why was an upward departure not warranted?
Well, all I have to say to that, Your Honor, is that the board, the expert panels who see hundreds of these cases every day, had these facts in front of them. They knew that Mr. Castro did these things, and they still assessed him a level 2 with just 80 points and did not recommend an upward departure.
But it's the discretion of the SORA court. I mean, the SORA court, I mean, it also took into consideration the amount of viewing time as well as the defendant's attempts to hide the images too. I mean, those things were two big factors I think the SORA court took into consideration too. I mean,
Yes, the court.
I mean, sometimes the RAI is not going to, account for that.
That's correct, Your Honor. The RAI doesn't account for everything. But here, again, the board did have access to that information, that he did engage in that behavior, and they still found that an upward departure was not warranted in this case. And just to go to the social science of it all, the social science is that the best indicator of a sex offender's likelihood of reoffending is his actual post-release history. And it's the single greatest factor in making an accurate assessment of the risk of reoffense. And he's lived a quiet, stable life for the 2 years between release and before the time of the SORA hearing, and he has not committed any new crimes afterwards. Over a number of years, Mr. Castro has also shown himself to be a contributing member of society. He's held several jobs, including right upon release when he was working as a delivery driver. He has continued to maintain strong ties with his family and contributes to the household. And again, I just want to repeat that following the terms of his supervised release, he has not committed any new crimes since.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. Elliot Robert Hamilton for the Office of the Bronx District Attorney. 2 years of not engaging in any conduct after being released from prison does not make up for 10 years of amassing a child pornography collection of thousands of images and hundreds of videos that he started doing when he was 14 years old. It did not take into account the fact that he had organized and categorized this child sex abuse material. It did not take into account the fact that he had a deviant online relationship with an underage girl where he directed her to create images and videos of herself debasing herself in sexually explicit ways. It did not take any of this into account in the risk assessment instrument, and the board's statement makes it very clear that these factors can't be taken into account beyond the risk assessment instrument to depart from a presumptive risk level. The prosecution met by clear and convincing evidence all of these factors, and the court providently granted the application for an upward departure using its discretion beyond what the board recommended to assess this particular defendant a level 3 sex offender. We ask that the court affirm the judgment.
Thank you.
Just to quickly go back to the prosecution's contention of the aggravating factors, there was less than half of the factors from the board's position statement which supported an upward departure. And the issue here is that they did not meet their burden in establishing clear and convincing evidence that wasn't already contemplated by the board. And I just want to reiterate, departures are the exception, not the rule. Here, we're not asking for a downward departure, and we're not even making a points argument. What we're asking this court to reconsider is whether the prosecution did indeed establish by clear and convincing evidence factors not already taken into consideration by the board. There's no underlying facts here where the board did not already have, where the panel of experts who assesses hundreds of these cases every day and found a risk level 2 to be appropriate for Mr. Castro based on the very aggravating factors that the prosecution citing to. We're asking for the appropriate risk level for Mr. Castro, which was already adequately assessed by the board and by the RAI and contemplated over and over again by case law in this court, sister courts, and the Court of Appeals. Thank you, Your Honors.
Thank you. 35 West Realty versus Pursuit.
Good afternoon, and may it please the court. My name is Norman Flitt. An essential issue that must be determined on any motion for dispositive judgment as a matter of law is whether admissible evidence exists to require a trial on any issue of fact. Now, let me comment on that to show why our position and record here now is different than the summary judgment pre-notive issue.
Isn't the only difference the handwriting expert?
No.
What, other than the handwriting expert, which clearly seems to be a conflict between the two parties since they've each submitted an expert, what difference is there?
Here's the difference. Since that first motion was made, we had discovery, and we took the deposition of one of Booston's principals. And at that deposition, and the testimony appears at 674 of this record, I asked who was present when this disputed amendment was purportedly signed. The answer was the two principals of Booston and the deceased Fred Hill. I then asked, was anyone else present? No. There are no disinterested witnesses who, on personal knowledge, can authenticate the disputed amendment. And it's
that was one of the issues on the prior appeal, the authentication.
The identification.
Authentication.
Pardon me?
The authentication was one of the issues on the prior appeal.
At the time of the prior appeal, however, it was not apparent that the affidavit on which this court relied to create an issue of fact was by an interested witness, nor was it apparent that there was no other evidence.
But we held just based on that, there was an issue of fact. I mean, we did address that specific issue and said that raised a factual issue.
At that time.
You have a subcategory of a broader category we already addressed and finding it raised an issue of fact, so I'm not sure how it's different.
The problem is always admissibility. How do you try this case? You have to put in the disputed amendment. Booston has to prove that that amendment is an authenticated document. They can only do it by interested witnesses. And this court's decision in Glatter that we cite in our brief and our reply brief, and the Court of Appeals cases say that that can't be done, can never be done solely by the testimony of interested witnesses. You need someone who's disinterested, on personal knowledge, who can attest to it, not a handwriting expert, because what this court said in Glatter was it doesn't matter for authentication whether the signature of the deceased person was real or a forgery. So if it doesn't matter that there was a forgery, you don't even need the experts. But we also had, in addition to what we had before, we had the depositions, we had Mr. Cherniak, we had an unequivocal expert testimony to prove the prima facie elements of our case. And I should emphasize also that when this court last had this before it, the last two lines of the decision were that the court, had considered Booston's other arguments and found them unavailing. Now, I looked at the brief that Booston submitted on that particular appeal, and it's interesting that they raise many of the same points that they raise in their brief here. For example, they say that the Weymouth affidavit was incompetent because he wasn't working for the entity at the time of the transaction. That was rejected. They say that 35 West did not meet its burden on summary judgment. That was rejected. Further, Justice Borak granted summary judgment, and this court found that issue a fact, saying, and the language is very, very critical, saying that the Farron Raschenfecker affidavit was sufficient to authenticate the document. The question becomes, at trial, would the Raschenfecker affidavit be even admissible? No. He would have to testify, and his testimony is precluded under CPLR 4519. And Supreme Court was absolutely incorrect in refusing to apply the dead man statute, limiting it to individuals and claims against estates. It is not so limited. In the Holcomb case, which we cite, the Court of Appeals says it's a remedial statute entitled to broad construction, and it shouldn't be limited. Justice Mendez.
It only gets applied against an executor, administrator, or survivor of the deceased. Here, the deceased is Hill, not the corporation, obviously.
Obviously not, because...
So the estate to be protected by the dead man statute is Phil Hill's estate, and that's it.
No.
What case have you got that says otherwise?
I got Herman, which is cited in our brief, where a corporation was allowed to avail itself. And where it applies is whereas here you have an individual who signs on behalf of the corporation, and that individual is essentially, as Fred Hill was, the personification of the corporation. And what I was going to say is...
You have extra time on rebuttal. Thank you.
Okay.
Good afternoon, Your Honors. May it please the Court. James Fishman for the respondent, Booston LLC. Your Honor, this case is so replete with disputed facts that it's hard to imagine why this could possibly be considered a summary judgment case.
Do you want to start with Glatter? How do you distinguish Glatter?
Sure. Well, Glatter did not involve a corporation. We have
It was two individuals, right?
Individuals. We have a corporation, not Fred Hill, but a corporation that sold a building to the landlord. There's no estate involved. Now, Mr. Hill died shortly before the contract went through, and his daughter ended up signing the contract or the documents at the closing. But Mr. Hill's estate wasn't involved, so there's no dead man statute issue at all. And Justice Kahn correctly said so.
What puzzles me is, isn't there a lawsuit that should be against the seller? Because the seller is the one who didn't disclose the amendment, right?
Well, the landlord is suing the seller. That's part of this lawsuit.
Right.
The Friedfield is a co-defendant. They're not on the appeal.
That's the crux of it, because I've read the record here. It's like they didn't tell us about this amendment. It was never disclosed.
Well, that's between the landlord and the seller. it doesn't involve us. We have a lease extension. We have, and the dead man statute has no applicability here, as Justice Moulton has correctly stated. And in the Herman case, which counsel referenced and which Justice Chan referenced, that's distinguishable because in that case, the individual was the sole shareholder of the corporation. So he and the corporation were like this. They were one and the same. There's nothing in the record here that says or suggests anything about Fred Hill's ownership and how much of the company he owned. And that's something that the landlord certainly could have inquired about but didn't. So the Herman case has nothing, certainly doesn't support their claim. And the Glatter case doesn't either because it's two individuals. It's not a corporation selling to a landlord, to another corporation. So I think, we have to put the dead man statute to bed here. It doesn't apply. And by the way, it really should now be called the dead person statute, but that's up to the legislature, I guess. But in any event, it's a non sequitur in this case. And Justice Chan got it absolutely right. There's no basis to include that. And I want to point out that Justice Kern and Justice Moulton were on the panel in 2019 when you held that the arguments that they're making now were insufficient for summary judgment, and they were tribal issues. So there's no reason to go back on that decision that Your Honors issued in 2019, where you said, yes, there's a statement in the Yellowstone complaint where the individual inadvertently said, my lease expires in 2020, not 2040. And that was the subject of a prior summary judgment motion, which was before this court in 2019, and you said, those are tribal issues. It was an informal judicial admission, not a binding one. It had nothing to do with the allegations in the lawsuit. It was totally a collateral issue, and it had nothing to do with the result in the case. So they can certainly raise that at trial, and I'm sure they will, but that's where this case belongs, at a trial. It's not a summary judgment. And as you said, we have competing experts on the handwriting. We have no doubt that our handwriting expert, whose qualifications are far superior to the landlord's so-called expert, who's actually a graphologist. This is not even a handwriting expert. So this case should be tried. And I want to point out also, this case today represents the 5th time that these two parties have been before the appellate division in the last 4 years, because they are on a relentless effort to kick out our client, a small business. It's a kosher restaurant where they're the last tenant in the last building in a 4-building site that they want to demolish. And they've been coming after him since 2012. It's enough already. Let's have a trial and let us move on. But I've never seen a situation where you have two parties before the appellate division 5 times in 4 years. That's
Fortunately, yes, we have seen that.
right, and yet we prevailed each time. We're still here. So, thank you, Your Honor.
Thank you.
Briefly on CPLR 4519. Justice Mendez, you applied that statute in a case brought by Proskauer Rose against a client, Duffy. Nothing involving an estate. It was a fee dispute, and you held clearly that the remedial nature of that statute was appropriate to bar testimony regarding what a deceased partner of Proskauer may have said. Similarly, and I want to emphasize this disjunctive.
But in that case, there wasn't a corporation on behalf of whom the testimony was being offered, right?
Proskauer Rose was the corporation who was entitled, or which was entitled to assert the rule as a shield. And also, are we not, is our entity, 35 West, not a person deriving his title or interest from, through, or under a deceased person? And let's assume corporations of
Thank you very much.
That's what the cases hold. Thank you.
Riddell Witt versus Algoma Hardwoods.
I'm sorry, Your Honor, but before I start, could you just remind me how much time I have on?
4 minutes.
4 minutes and rebuttal?
You didn't ask for rebuttal.
Oh, I asked for 8 and 4, but, okay.
You asked for 8 and 4?
Yeah,
I'll give you 4 and 1. That's not my recollection, but.
okay.
Because I always give rebuttal unless someone asks for it, so I don't know how I would have not, but I'll take your word for it. I'll give you 1 minute
Okay.
rebuttal.
Good afternoon. May it please the court, Thomas Carruthers for Appellant TM Cobb Company. The narrow issue here is whether specific jurisdiction can be exercised over a non-domiciliary under Section 302A. Under the Court of Appeals ruling in Lamarca v. Packmore, this requires the court to undertake a two-step inquiry. First, is there jurisdiction under Section 302A? And second, if so, does the exercise of jurisdiction comport with due process?
And you argued below 302A2 meant that there was no long-arm jurisdiction.
Excuse me?
You argued below 302A2.
Correct.
Right, and that's the analysis you'd like us to apply.
Yes.
Correct, and so that would mean the locus of where the tort took place is where the door was manufactured, correct?
Correct.
Please continue.
Okay. The burden here is on the plaintiff. Plaintiff has failed.
Did you rely on that, or did they rely on that? I mean, they made the argument that it was a tortious act within the state, right?
They argue that the tortious act was the exposure.
Right, so their argument for jurisdiction was there was a tortious act within the state.
That was their
But
argument.
it wasn't your argument, it was their argument, right?
Correct.
They're saying that the tortious act is the manufacture, and that happened in California.
Correct. There was no tortious act in New York. The cases in New York are clear. Most recently, the SOS Capital case found that the mere fact that an injury took place in New York does not constitute a tortious act in New York.
Because there's actually another provision that addresses that, right?
Yes,
A tortious act without the state causing injury within the state.
correct.
In fact, I think Supreme Court, when it made its determination on the A2, kind of mixed up the standards for A1 and A3, right? Because it said that you did not sell distributed doors in New York, so it didn't kind of fit into the A2 argument that you were making.
Well, they made an argument that 302A2 applied.
Right. The Supreme Court made the analysis did not fall into the A2 analysis.
No, the analysis they relied on in the Kruder case was actually a 302A1 case, which is a transaction of business case. So we think they applied the wrong standard in analyzing it. But in any event, plaintiff did not meet either prong. First, there's no jurisdiction under 302A because there was no tortious act here. Second, due process requirements were not met because there's no minimum contacts between TM Cobb and the state of New York. TM Cobb is and always has been a California corporation, manufacturing operations in California, no presence whatsoever in New York. Those facts are undisputed. Plaintiff doesn't even allege anything to the contrary, nor do they point to anything else to demonstrate otherwise.
Thank you. Are there any other questions? Any questions? Okay, thank you.
May it please the court, Chris Romanelli of Whites and Luxembourg for plaintiff respondent Holly Riddell Whitty. Our position is that the Supreme Court felt we met our burden to show that under 302.
Don't you have to show a tortious act within the state? Don't we have a number of cases that say you can't show a tortious act within the state just because someone was injured within the state?
The cases that they cite differentiate a mere occurrence within the state with selling, directing products to New York State, which I'm going to show that the Supreme Court said that we met our burden. We have Mr. Whitty's explicit testimony, court's words, uncontroverted, my words, that he was exposed to asbestos from newly installed TM Cobb fire doors in New York for 13 years. We had the testimony of one of their witnesses. There are no documents, no air bills, nothing showing sales. We don't have them. They don't exist. They admitted that he didn't look at them and he had no personal knowledge. So we have nothing from them. We have our guy's testimony for 13 years. They show that this is more than just a happenstance occurrence. This is a direction of products to New York. This is exposure to asbestos in New York. This is, as far as our guy is showing, sales to New York. To differentiate their cases, the SOS case cites the asbestos case Favala, which is all about exposure in Connecticut, where they say if you're exposed in Connecticut, you really can't bring against somebody in New York for somebody who doesn't do a little more than that. So that's different. And all of the cases differentiate between a mere occurrence, you're driving a car that you got somewhere else and an accident happens in New York with a defective tire, and stuff that was sold in New York, exposure. All the cases that have been differentiated here show
What's the evidence that it was sold in New York?
Mr. Woody's testimony,
He
explicit testimony.
testified that it might have been this store. He wasn't even sure. So how is that testimony that it was sold
I disagree
in
with
New
that,
York
Your
and
Honor. I think that
distributed-
if,
Let me finish the question.
I'm sorry, Your Honor.
How is that evidence that it was sold or distributed in New York?
We have his testimony that they were sold and installed in New York. It's repeated throughout the record. And we have the court below's words, explicit testimony, and we have nothing.
What's testimony?
No, the court's using the words, his explicit testimony. I like those words, that's why I keep saying it. Combined with nothing from their side. Somebody who had no personal knowledge, he had no documents to review, he had nothing to go on as far as sales. I think that shows everything that we need to show that we've met our burden of the 302A2.
So let me ask you, if the plaintiff, when he answers the questions regarding being exposed to the product in New York, is sort of equivocal, and then when the defendant is asked a question as to whether or not they distribute the product in New York, if they make sales in New York, what their regional market is, they answer the question in a very assertive manner, saying, we never distribute in New York, we never sell in New York, we are circumscribed basically to the West Coast because it would be economically unfeasible for us to sell in New York.
He had no personal knowledge.
No personal knowledge?
None. Jeffrey Cobb had no personal knowledge.
What about the other Cobb? Because you had two witnesses
I
testify.
understand that. The other Cobb had very little personal knowledge about anything.
Okay.
That's my
Thank you.
position.
Any other questions? Thank you very much.
Thank you, Your Honor.
No, you have to, no, I'm saying thank you very much. You go.
You give him rebuttal. Oh,
No,
okay.
he got rebuttal.
Counsel argued that there is evidence of sales and distribution to New York. That is wholly unsupported by the record. There's absolutely nothing in the record to that effect. Second, respondent's counsel said that the testimony of the plaintiff was unequivocal. That is, again, contradicted by the record. The question asked by counsel to plaintiff was, do you know if any of the doors being installed were manufactured by T.N. Cobb? No, I can't be certain. Another question, do you specifically recall if these T.M. Cobb fire doors were being present at the 81st Street studio were manufactured by T.M. Cobb? No, not specifically. So,
Well, let me ask you, I mean, the question, unless I'm reading it wrong, I thought the plaintiff's opposition below, it focused on A2, not A1 or A3. Didn't make any arguments with respect to A1 or A3, correct?
Correct.
Plaintiff, in opposing your motion to dismiss.
Correct.
With A2, if you back it up, it's just basically if the Tortious Act happened in the state, but it was manufactured in California, there was no Tortious Act in New York. Therefore, A2 doesn't work.
Your first argument.
The first argument.
yeah,
All this distribution discussion and all the transactions, that's A1 and A3. That doesn't come into play.
well, our position is there's nothing under A2.
Well, they never opposed to that. They
never did,
advanced the argument.
and never
Okay.
presented any
I got it.
evidence otherwise.
Thank you.
Thank you.
Thank you, Your Honor.
People versus McKinney.
Good afternoon. For Michael McKinney, I'm Claire Glass with the Legal Aid Society. Now, without excusing the underlying conduct here, we urge this court to run all of Mr. McKinney's sentences concurrently to better reflect Mr. McKinney's age, his serious chronic health conditions, while also addressing what happened here and society's peniological interests. Now, first, we all know that the rates of recidivism precipitously decline once someone turns 45 and onward. Mr. McKinney is 48 years old. He has multiple chronic health problems, as I mentioned, including cardiovascular disease, for which he had to have a stent implanted, and he requires an ongoing course of medication, among several others. Mr. McKinney has suffered with a disease of addiction and related homelessness for over 20 years for the vast majority of his adult life. And those issues are directly linked to the cases before this court today, as well as all of the cases in Mr. McKinney's past. This is someone who needs support in the community. And relatedly, Mr. McKinney accepted responsibility for his actions here, both in pleading guilty and also in candidly reporting to the Department of Probation during his interview that he committed this conduct in order to support his dependence on drugs. Moreover, there's no inherent logic as to why this one of 3 sentences should have run consecutively. And again, this isn't to minimize the severity, but just to put it into perspective. The consecutive
That's what he pled to, correct?
Pardon?
He did plead knowing that that was what was going to happen, right?
He did, Your Honor, but that doesn't curtail this court's ability to look at the sentence and determine whether it, satisfies both his needs and the peniological interests here. And there's no reason that this sentence should have run consecutive. These were no physical contact with any of the complainants.
I thought in one, on the February 22nd one, he pushed the woman to the ground.
Well, Your Honor, that is a different case. What I'm arguing specifically is that the one sentence that ran consecutively should run concurrently, just like the other 2, and that there's no reason that it shouldn't, in light of the fact that that one case that runs consecutively involved no physical contact with the complainants, led to no permanent monetary or material loss on the parts of any of the complainants, and resulted in a nonviolent conviction. And I'll also note that we're not asking for the minimum here that Mr. McKinney could have gotten across the board on these cases. What we're asking is for a modification that would make this consecutive sentence more accurately reflect the circumstances of the case at hand, as well as Mr. McKinney's circumstances. And I do want to add, too, what the practical effect of this modification would be. So Mr. McKinney's current sentence is 4.5 to 9 years. So if the court were so it's 4.5 to 9 years. So Mr. McKinney is already scheduled to appear before parole in June of this year. So if Your Honors were to grant our request, it would just move Mr. McKinney's parole hearing up, give or take about 3 months. And at that point, it would not constitute, it wouldn't be tantamount to Mr. McKinney's immediate release. It would just mean that a few months earlier, he would go before the very same parole board that would make the same determination about whether it was appropriate at that time to release him to its supervision. And, if it were to make that choice, the parole board would be supervising Mr. McKinney for 2 years. And if not, Mr. McKinney would carry on serving the remainder of his 3 to 6 year sentence.
Thank you.
Thank you.
Good afternoon, and may it please the court, Faith Detrolio for the people. Just to begin, defendant did validly waive his right to appeal in this case, which does foreclose his excessive sentence claim, but in any
I wouldn't spend too much time on that. The colloquy is really poor, in the oral colloquy. Why don't you move on to the merits?
Yes, Your Honor. Defendant's sentence was fair and appropriate in this case and should not be disturbed on appeal. Defendant was originally charged with 7 felonies, and he was able to discharge 4 of those in this plea agreement. And it should be noted that this was a global disposition, which included many other theft crimes that were disposed of. Additionally, the record reveals that the people had a straightforward case against defendant, including eyewitness testimony and surveillance video. So the likelihood of him being found guilty after trial was bless you, Your Honor, would be very high and would have resulted in a much higher sentence than the one that he received as a result of this plea agreement. Just one more thing, defendant did have a lengthy criminal history. These convictions are his 6th, 7th, and 8th convictions in New York, and he also has 33 prior misdemeanors. If there are no questions, we ask that you affirm.
Thank you.
Thank you.
I presume I shouldn't go into the appeal waiver
As far as I'm concerned.
at length, but I mean, just very briefly, the court stated simply, and I quote, "You can't appeal." The court, misinformed Mr. McKinney that this fully extinguished his right to appeal, and that alone renders the waiver invalid. And, I will say, again, Mr. McKinney does have a long record, but as I already said, these are all related to Mr. McKinney's struggle with addiction and homelessness, and he would be better served with a shorter sentence that would still be quite substantial, 3 to 6 years, and that would also serve the peniological interests of society. As I stated, and I also note that the other cases that this plea agreement wrapped up were nonviolent, and as the prosecution stated, all of his other cases were crimes of poverty. This was theft, this was the possession of drugs, and that is why this consecutive sentence just doesn't adequately reflect what happened here or Mr. McKinney's circumstances. He has matured, he's 48 years old now, he has major health problems, and this consecutive sentence represents an overvaluing of this case. For no particular reason, there was no contact with the complainants, no monetary loss, and for all of these reasons, we urge this court to adjust Mr. McKinney's sentence to run concurrently to the others. Thank you.
Bloom versus Hilpert.
Good afternoon. If I may please the court, I'm the appellate defendant. The underlying action is matrimonial. I'm asking this court to vacate the judgment of divorce based on respondent's fraud. If you can't do that, I'm asking this court to please send it back for recalculating child support and support payments. There's also some real estate in question regarding child support. The finding of the lower court was based on income which no longer existed at the time of trial. The referee took my 7-year average, ignoring my last 3 years in the record. The referee also took my former wife, who claimed no income. She imputed over $300,000. Instead of grossing it up for taxes, she deducted FICA and New York City taxes. My income was not deducted for FICA. So there's some errors here. Furthermore, regarding child support arrears, the referee took 20 months to make a decision. And she simply assumed that I made no payments in the 20 months and added it to my arrears, which is absolutely not true. There's no probative evidence, no hearing. I made continuously payments during those 20 months. Additionally, she completely ignored $151,000 of payments that I documented during trial. It's there black and white. She completely ignored it. Before I talk about the real estate, because I have only 3 minutes, I'd like you to understand that my former wife and I ran separate businesses, separate bank accounts, filed taxes separate. Nothing was ever commingled. My real estate business, I run a small real estate business. I started it before the marriage. It was deemed as separate property. It was never challenged. It was undisputed. There was a building that was purchased during the marriage. The referee claimed it was marital. It is not. It is owned by a partnership. The funds came from a third party that was not a party to the divorce. And my premarital business, which was deemed separate, provided the remaining funds. There was never, ever any dispute that these funds were commingled. They stayed separate. They kept an identity of separate funds. The partnership had its own bank accounts. And the referee appointed a receiver, which and there's case law, she had no authority to order the sale of a partnership property where the parties had no due process. They were not parties to the underlying divorce. As it relates to my home, which is in my name, and I'm paying for the mortgage, that property was also purchased with premarital funds from my premarital business.
Thank you. We have read your brief, so we are familiar with all your arguments. And we'll
It was hopefully voluminous, but do
Thank you.
you have any questions?
No, nothing.
Thank you, appreciate it.
Chavez versus Cirilla.
Good afternoon, Your Honors, and may it please the Court. My name is Travis Wong for the Plaintiff Appellant. Our position is that the Supreme Court overlooked material issues of fact with respect to defendants' contributory negligence. There can be more than one proximate cause of an accident, and in this case, plaintiff's testimony establishes issues of fact with regard to defendant's negligence. And defendant failed to establish prima facie that it was not contributorily negligent. Plaintiff testified specifically that the defendant driver was 3 car lengths behind her vehicle when the front half of her car was already in the lane. She then testified.
Counsel, how do you square that with the photos that are the record at 157, 158 that show, you know what they show, essentially the car hitting, your client's car hitting the wheel well of the truck?
I would say there are 2 explanations for that. First of all, the photos does not account for movement of the vehicles after impact. And secondly, plaintiff testified specifically that the truck continued towards her and tried to swerve around her, causing the accident. When plaintiff's testimony is taken as true, which is required for a motion for summary judgment, these create issues of fact with regard to whether defendant should have seen or there was to be seen and tried to avoid the accident. I mean, here we have an issue of 3 car lengths. Defendant testified he was traveling 5 miles per hour. That's an issue for a jury. I would also like to just note that the case relied upon by the Supreme Court and defendants, the Davis case, does not support the proposition of law which it purports to support. In fact, the Davis court specifically noted that the vehicle in the driving lane and the parked vehicle both may be contributory negligent. The issue in that case was that there was a passenger, and the passenger was not found to be negligent. If you have no further questions, I will save my rest for rebuttal.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Nicholas Cardasher from Cullen and Dyckman for the respondents. The photograph says it all. I know that the plaintiff says that they don't accurately depict the position of the vehicles at the time of the accident, but that's not what the plaintiff said. She said that immediately after impact, her car stopped, didn't move. So there was no movement. The driver, Mr. Zaria, stepped out of the truck, took the photographs.
I mean, yeah, the position of the wheel kind of gives you a suggestion as to what happened. I mean, it looked, from the photograph, the truck had already passed the car, correct?
The truck was past the car, and she basically drove into the truck.
It would have been, if the photo of it was the other way around, where the front of the car was in front of the truck.
I think we'd be talking about a different story.
Yeah, totally different story.
Yeah. So I think the photograph says it all. Justice Perez was correct. And
well, didn't she testify that she said she saw the truck coming?
She actually contradicted herself in her testimony. She said that she saw the truck, then she said she didn't see the truck, so it depends on which version you accept.
Okay, right. Because I thought she said at one point, she said that she thought the truck was going to slow down.
She did. She did testify that she said that the truck was 3 car lengths behind her, and she assumed that it would slow down, and she went forward. But then, when asked again, she said she didn't see the truck when she began pulling out. So
she saw the truck when she looked through her rear view mirror.
She said that, correct.
She never turned her head and looked over her shoulder to see where the truck was.
Correct, Your Honor.
and she pulled her vehicle from a parking space into the lane of traffic.
Right, at 5 o'clock in the afternoon. And you can see in the picture. there's-
The other thing about, she claimed that there was a swerve, that the truck
claimed
swerved,
that
but
the
if you
truck
look at the
swerved, but
photo,
if the truck swerved, it would have been in the opposite lane.
yeah, okay.
There are no other questions or rest of the
This is not an AI-created photo, is it?
I hope not, Your Honor.
Dinah asked that question. All right.
Thank you very much.
I will be quick. I would just like to say that if taken as true, plaintiff's testimony does create an issue of fact. And the interpretation of a photo is a factual issue that should be left to a jury. If you look at the cases, Inesta v. Florio, Espinoza, those are cases that are similar to this, in which a driver pulled out of a parked position, and the court still found that there were questions of fact as to whether the driver in the moving lane was negligent, because they should or could have seen what was there to be seen and failed to take appropriate actions to avoid the accident. In this case, there is at least a question of fact that should be for the jury. The defendant may have been negligent, and I will rest on my brief.
Thank you very much.
Thank you.
214 Lafayette.
Good afternoon, Your Honor. May it please the court. I'm David Slarsky on behalf of the appellant Acasa Holdings. There are a number of issues in our brief, but I want to focus the court on two in particular. One is the res judicata error that the IAS court made, and the second is whether, when you correct that error, the undisputed facts establish my client's adverse possession.
Why isn't there res judicata against you?
I'm sorry?
Why isn't there res judicata? Why the Supreme Court error in saying it's res judicata?
The reason that they said is it misapplied the Paramount case, but the issue is, the reason res judicata cannot apply is because in the prior litigation, and Justice Owing, you were on the panel that heard us, this question for additional relief of encroachments on the easement was never raised in that litigation.
Your client could have raised that. You were the plaintiff, and you could have raised that issue, that either alternatively that there is no easement, or if there is, that it's been that you've acquired, that it's been essentially obliterated by adverse.
The issue in that litigation was whether the easement was properly given and recorded.
I understand,
okay?
but you could have also raised the other argument, which you're now raising.
We are raising it as a defense.
But you could have raised it affirmatively.
We could have, and if we were here now, the IAS court correctly dismissed it.
Given that you could have raised it then, why doesn't it come within?
Because it's a new request for relief. This is what the IAS court did, is it took the Paramount case and it took it upside down. Paramount case maps exactly onto 214 Lafayette's position. 214 Lafayette, as the defendant in that case, should have sought the relief it's seeking now. And if it had sought the relief then, when it was sued.
Let me interrupt for a second. How could you not have known, when you were bringing an action to quiet title, that if you were unsuccessful in that action, the natural next step would be that they would ask to exercise your easement and have any encroachments removed? How could that be a surprise in any way, that was going to be the next step that occurred?
I think it's a surprise because for 20 years, they had simply walked around the stairs. And so when the
But now there was a litigation which involved the issue of whether the easement was in play. Knowing that, and knowing the principle of res judicata, that you have to bring forth all your arguments, and that adverse possession can be either an affirmative defense or an affirmative claim, you certainly had the right, when you brought the action to quiet title, to include in the alternative that not only was there defective title, but that even if there wasn't defective title, you had obtained possession to adverse possession. So how do you get around the res judicata?
I just want to point out, there was never a question about whether the stairs needed to be removed. There was never a question, so my client never knew.
The issue was, you're saying a client never knew, but if the issue is whether or not there's a valid easement, isn't the natural sequela of there being a valid easement that anything that's blocking that easement, once there's a determination that it's valid, would then potentially be a request to have it removed?
No,
Well,
this is
why
O'Brien
is there-
versus Syracuse all over again. Are now seeking relief in this court that they could have sought as a counterclaim in that prior action.
But
They
there's
could have
no
said,
requirement, no one's asserting res judicata against them. This is only coming into play because the res judicata issue is being raised. And if the res judicata issue is being raised, if you had brought the adverse possession in the prior action, it wouldn't have been a counterclaim.
I would
It
agree with
been
you
a
if we were
claim.
here. I would agree with you if we were here seeking relief that the easement was defeased. But this goes to, again, our equitable relocation argument. We have consistently
When did
said,
DOB weigh in about that? When did the Department of Buildings say, hey, there's another way of doing this access?
well, after they made this new demand for new relief that they wanted our front stairs removed, we took it upon ourselves to go to DOB and said, what if we just reroute the easement? Let them take one step to the right. We went to that expense, that cost, that effort to show that there's an equitable alternative here. Take a step to the right, relocate the easement.
What year was that? Do you remember?
That was in 2019 or 2020. Again, it's in response to their new request for relief. The key here is that had they, when the issue was brought to the court, said, look, in the alternative, there's a separate issue here, which is do these stairs encroach on the easement, right? Because the issue of encroachment is a separate issue than whether...
Was there any real dispute that if it was a valid easement, that these structures were on the easement?
From my client's perspective, there was no dispute that they could just take a step to the right, and so it was never
Why bring an
litigated.
action to quiet title?
The
I mean,
court,
what
the
was
court
purpose of
acknowledged that it was
action?
never litigated. The court acknowledged...
No, that wasn't my question. Why was there a whole action to quiet title if there was no problem with any of the structures? Why would you bring an action to quiet title?
We brought an action because there was ultimately a question about whether that property could be developed, could be conjoined and developed without any easement at all, which my client didn't know about because of the indexing error by the city. Once this court determined that the easement was properly recorded and we had an inquiry notice, we said, fine, you can, we said, fine. We accepted the decision.
What obligation, I mean, I think there could be a compromise here, but obviously that's not the function of our court, and the court below noted that, but we can't delve into that.
Let me pivot to...
Putting aside the issue of whether there could be a compromise, which I encourage both of you to discuss too, putting that aside, why aren't those issues in?
Let me pivot for 1 second to our latches argument, because this is critical. If they are correct, and they say that the adverse possession claim wasn't ripe until the 2018 decision was issued, which can't be the case because it's inconsistent with the position that they took that it was properly recorded in 1981. They could have sought the removal of our encroachments at any time for 20 years. But if they're correct, may I address the latches point for 1 second, Your Honor?
Let me ask you a question about it. Is there a way that one could argue that even if the adverse possession claim is res judicata, that you could still address the laches claim? And
Yes, Your Honor.
How would that work?
Yes, Your Honor, because if they had brought up the issue that they had with our encroachments at any time in the 20 years, we would have said, hold the phone. Why are we going to remove things that have been standing there for 20 years? Set aside the dispute about recording the easement and whether the easement was properly recorded. If they had at any time in 20 years or in the litigation, brought up that they wanted us to remove our stairs, we would have then asserted adverse possession with respect to those encroachments. They sat on their rights. We are now precluded from asserting our adverse possession defense, purportedly, even though it's new relief that they're asking for after the prior litigation. If we are precluded, then it's classic latches. We have been legally prejudiced as a result of them sitting on their rights for 20 years. They knew that those encroachments were there.
Okay, let her ask her.
I'm still imagining your conversation with your client when you brought the first action, in which you say you're going to bring an action to establish that they have no easement, that you weren't given notice of the easement and therefore it's not valid. And they say, but what if we lose on that? We have all this stuff there. What do we have to do with that? So why wouldn't you have addressed that at the time?
I don't believe that conversation ever came up, Your Honor, because they never asked to remove the stairs. They never had an issue with taking one step to the right. The conversation never occurred. It didn't come up in the litigation. And in fact, when I deposed Mr. Nispel, where it came up was after the fact, and he said, well, this was important to Tony, so now I want the stairs removed.
Okay,
this is
let him ask his question.
I have one quick question about the first proceeding that we've had here, the quiet title proceeding. Did the easement come up initially when you commenced that action, or that came up during the proceedings? What was the impetus of the quiet title?
The impetus of the quiet title action is that my client woke up one day and saw that that 214 Lafayette had gone downtown and somehow gotten this easement recorded. And what they had done is fix the indexing error. Instead of going to their neighbor and saying, hey, we have this easement, there's an error in the record, let's figure it out, they went and they went to the city and re-recorded the easement. And that set everybody off on the wrong path. And now you have two neighbors, and essentially what this action is, there's no need, they're seeking equitable relief. They're asking for my client's front stairs to be removed, when all they need to do is take one step to the right, and we've shown that you can equitably relocate the easement, which again, the court didn't hear.
Let's hear from opposing counsel. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. David Fiveson for the respondent, 214 Lafayette. At page 79 of the record is the excerpt of the complaint of the underlying action. And on page 5, paragraph 5, they brought the first action to declare that they hold the premises free and clear of any interest of my client. Now, in connection with that action, in connection with that claim, it is inextricably a claim of adverse possession. They were initially claiming that they're bona fide purchases for value, and therefore they were not on constructive notice of the easement. This court held, indeed, when they purchased it in 2011, they were on constructive notice.
That's the issue that was being litigated in the prior action. How is that res judicata as to the adverse possession?
Correct. But it would have been res judicata because the claim of adverse possession is intimately and inextricably intertwined with their claim that they hold the premises free and clear of any interest of my client. So it should have been brought at the time. Now,
let me ask you a question about the latches. Let's say, assuming we agree with you that it's res judicata, why couldn't they bring up the latches argument now?
well, latches doesn't apply here for multiple reasons. First,
That's not on the merits, but just procedurally, why couldn't
because
they still address?
there's no delay, there's no
No,
prejudice.
no, I said not on the merits of the latches argument, but why would, even if res judicata barred adverse possession, why would it bar latches?
Well, what they're appealing is a judgment that declares that they're obligated to remove permanent obstructions, which they knew when they purchased in 2011 existed, and which when they purchased, they were on constructive notice of my easement, a fire easement, may I add, that they have to remove them. Now, that easement has never been used. It's a fire easement that comes across, and both sides conceded we never used the easement. We only knew of the obstructions in June of 2018 or 19 when my client took a deposition. That's when my client first realized, hey, there are obstructions here. Now, we did not make the demand.
The obstructions are visible from the sidewalk.
The obstructions are not, well, not from our building, sir. Our building,
If you walk on Crosby Street, right?
Crosby Street has
They're
a,
right there. There's the fence. I saw the photos. I mean, you saw the photos. They're highly visible. So how did your client not know about them?
well, my client testified he did not know about it. But the point of the matter is, in latches, there's no latches claim because when they bought it in 2011, the obstructions already existed, and consequently, there was no detrimental reliance to them. Secondly, there was a claim.
Well, isn't the latches have to do with removing it, that they relied on that it could continue to be there?
No.
And now you're asking for it to be removed, where it's been the status quo for so long. Why isn't that detrimental reliance? They're relying on the fact that no one ever requested them to move it all these years.
Well, Your Honor, I don't believe there is any detrimental reliance because when they purchased it with constructive notice of my easement and of a fire easement, and they knew that those stanchions were there. So there is no reliance. They were already there when they
What
purchased
about
it.
9 years of you not saying anything, your client not saying anything? Isn't that reliance?
That may be a delay if you want to take the position, Your Honor, that we could have seen them from the street. But that's no reliance. They were using it. They had use of that premises for 9 years. Moreover, there was a arbitration proceeding before Justice Helen Friedman, where they were
In the record? Is that in this record?
Yes, it's in the record. What happened
Is
was.
it in the record before us?
Yes, yes. There was an arbitration proceeding where they were awarded $130,000.
Oh, against their title insurance, yeah.
That's right. And they accepted that. And therefore, there was compensation for any injury that they claimed they sustained.
That's just for the diminution of value of the property, that's all.
That's for the diminution
It's
of
not for-
value. Justice Friedman held that it may be that the fire marshal.
Justice Friedman say that's how much it's going to cost to tear out the staircase and the fence?
What she held is that the fire marshal may require them to remove this from this easement, and she held that and they were.
What year was that?
This was in 2018, and what's important is that they argued before this court in 2019, having accepted that money for compensation of their alleged injury, that the easement should be vacated and terminated and held free.
Are there any other questions? Go ahead.
To the extent that the remedies at issue here are all equitable, how do we deal with the fact that your client in his deposition basically said he wanted everything removed because they were important to Tony Krantz, and which seems rather petty and inconsistent with the good faith required for equitable relief?
You know, there is a history here between these two parties.
Right, but that's the evidence in the
Well,
record against your client. I didn't see anything comparable.
Well, I dealt with it, I believe, in the last point of my brief. And my client is deeply concerned that if the easement is somehow modified or vacated, he's going to lose, or he is threatened to lose, the certificate of occupancy for his premises because you require.
What about the Department of Buildings determination that you can have an alternate easement? Doesn't that protect your client?
Your Honor, I dealt with that in my brief, and I cite the record. That is not. I cite the specific references in the record that was not a final approval, that approval and application was based upon the easement of record, which did not show the stanchions, did not show the prior obstructions and all the brush and the trees that I have photos in the record.
Thank you. Any other questions? Thank you very much.
Let me clarify just a couple doctrinal points, Your Honor. If this were just us coming back for a second bite at the apple to say that the easement was invalid, I would agree res judicata applies. We can't bring that claim. Our pleading was a belt and suspenders pleading that had that affirmative claim, but at R-167, our first affirmative defense to the new request for relief that they are seeking was an affirmative defense of adverse possession. This is the proper application of Paramount and O'Brien versus Syracuse. They could have sought this equitable relief that they're now seeking, removing our front stairs, our security fence, the wheelchair lift into our building. They could have sought that relief in the quiet title action. They didn't. They should be barred from bringing it here. I'm not arguing res judicata, though. I'm just saying you can't apply res judicata against my client if
There's
you're not.
no compulsory counterclaim, though, right? I mean, they didn't have to do that.
They didn't have to, right? But what the court did was it barred our defense.
Yeah, I see what you're saying.
Okay? It barred our defense. And what all I'm saying is if you actually get to the merits of our defense, there's no question adverse possession gives us the right to maintain the encroachments, even if the easement.
Point. They should have brought it earlier so
They
that we
should
would
have
have litigated this whole thing last time around.
Exactly. And when you marry that with the record evidence of the bad faith and the unclean hands, we were denied our day in court. And Justice
Sorry.
Moulton, you've quoted this.
No, your time's up. Any further questions? Thank you.
Thank you, Your Honor.
People versus Rivera.
Good afternoon. I'm Catherine Martone on behalf of Mr. Rivera. The SOAR hearing court here erred in applying the override for inflicting serious physical injury. Under the guidelines, the penal law definition of serious physical injury applies. This requires proof of physical injury, which creates a substantial
Risk of death. Now, being shot in the face doesn't do that?
That's I understand that's the district attorney.
You know, it's near,
I
obviously,
think
it's an obvious question, counsel. How do you deal with that?
Yeah, and the problem with it, Your Honor, is it confuses the issues. They're arguing essentially that his conduct created a risk that the complaining witness would receive that type of injury. But what they needed to show to apply the override is that she did, in fact, receive that type of injury. So sometimes
I'm sorry,
a person could be shot in the face.
I just want to get the facts straight, because I may be wrong. I thought he shot her. Your client shot
Yes,
her.
Mr. Rivera shot the complaining witness 3 times. But what the prosecution needed to prove was that she received injuries as a result of that conduct, which...
So the fact that she had to drag herself away from him because she was unable to walk after being shot doesn't constitute a serious injury?
Judge, we needed this record to establish that. This record needs to show what the nature of the injuries were. And at page 10 of our brief, we cite 2 authorities which provide facts demonstrating the types of injuries that are required to meet this very stringent high standard. We don't know, based upon the fact that in the immediate aftermath of the shooting, she did that. I think you said she crawled up a hill. That's not a showing, a demonstration of protracted impairment of health. As the authorities we cite in our brief show, even some limitation that goes on for some period of time after the injury is sustained, for example, having to use crutches for several weeks, is not sufficient to show a protracted loss or impairment of functioning. It's quite a high standard here, and we have no proof in this record whatsoever that the injuries themselves were serious and consequential, Your Honor.
Of course, the burden is lower here in a SORA case.
Yes, and I think that also is an observation that confuses the issue, because the burden of proof is how persuasive was the proof, whether you have to be convinced beyond a reasonable doubt or whether you find the evidence to be clear and convincing. But that's different from saying that although the penal law definition, which applies according to the SORA guidelines, require the prosecution to prove something that was serious and consequential, the prosecution can prove something that may have been relatively slight or minor. We just don't know because there is no evidence in the record.
Thank you. You have time to rebuttal.
Good afternoon, Your Honors. May it please the Court. Jonathan Sklar for the people. Your Honors, the SORA Court was warranted in granting a Level 3 override for serious physical injury or death when defendant was hired to kill the victims, raped and sodomized, i.e. shot her 3 times, once in the face, once in the lower back.
Unless I'm missing the argument is that there was sufficient evidence for the SORA Court to make that finding of clear and convincing evidence that there was serious injury that occurred here. How do you respond to that?
Sure.
What was before the SORA Court? My notes said there was a photograph of her face having a bullet hole in it.
Sure. So defense obfuscates this issue, right? One of the definitions of serious physical injury is creates a substantial risk of death. If shooting someone 3 times, once in the face, the lower back, and the butt, where she has to drag herself off and then gets the bullet surgically removed, does not create a substantial risk of death, then nothing does, Your Honors.
I guess that what they're arguing is that what was to back those statements up, those facts up? I mean, that's for the sense is that there was...
Oh, sure. The grand jury testimony, which is reliable hearsay under Mingo, is clear, supported by clear and convincing evidence. Also, the case summary, Your Honors. And I'll also note that defendant acted in concert with his accomplices to murder two people, and the Level 3 override also applies in cases of death. So there was clear clear and convincing evidence. The cases she relies upon is all proof beyond a reasonable doubt, which is a significantly higher standard. And Your Honors, I think you understand there is no basis for a downward departure where the static risk assessment itself assessed defendant a moderate to high risk based on a discretionary override and noted his incentive to commit this kind of behavior again, this kind of conduct again, because he has a incentive to gain money. Anyway, we ask you to affirm. Thank you.
The problem with the proof here is that there's no evidence regarding the nature of the injuries themselves. There's just no proof
But the
whatsoever.
grand jury testimony is there, right? I mean, you're not are you challenging the grand jury
I'm
testimony?
not saying that the grand jury testimony could not be used in this proceeding. There's no evidence in the grand jury testimony regarding the severity of the injuries that occurred here.
Are you referring to medical evidence, to some type of expert?
I am referring exactly to that, Your Honor, to some sort of medical record which would establish how severe the wound was.
I thought that's what you were arguing.
Yes.
Was the photograph of the bullet to the face is not sufficient?
No, Judge, it's not, because there's no evidence as to when that photograph was taken, how long that injury appeared for. The type of it's not just a facial injury. It's an injury that is serious and protracted that is required under the statute. Your Honor.
See you tomorrow. Hasta mañana.